उसको दोगा तो
Sorry, I didn't send an apology. I had mentioned these matters. Your Lordship was pleased to allow the mentioning. Two matters were supposed to be upgraded. Those matters
They are not there.
They are not there. Item number 588.
There are several mistakes in the list.
And item number
These may be
600
one of
is
them.
list.
অনেকগুলো mistake আছে list. অনেক.
Item number
Please
588 because they are proceeding with the show cause.
এগুলো আর্জেন্টে বলেছিলাম দিতে।
Miller, may I?
হ্যাঁ।
Miller, may I?
Sorry.
Miller, may I mention with regard to item number 689 of today's list, Miller, 689. But this is urgent matter. Malo heard twice this matter. This is regarding appointment, illegal appointment of a headmaster in Aramang High School. So, Miller, kindly upgrade the matter. Otherwise, matter will become infractious.
Why infractious?
The 689, Miller, 689.
So why will it become infractious?
No, if the matter is not heard immediately, the matter
Why? If it is heard on 2nd January, why will it become infractious? It will be heard.
No, then the first week of January can't heard of the matter.
Yes, so don't mention those matters unnecessarily.
Another mistake in the safety tax matter, which was heard by your lordship last week. It was being heard under the heading fixed matters and was directed to appear under the same heading, but it's appearing not only under a different heading, but it's languishing at the bottom.
Which item is that?
55 lordship.
এটা দেখুন, এটা আবার urgent motion কে urgent-এ আনুন এটা উপরে. It will appear as urgent motions.
My lord, this I have mentioned in the last week also, my lord. This is urgency. There is a recovery notice. I have challenged an reassessment order in old regime, that is in Jiken Drive, sir. We have filed an objection. It was not disposed, and they have passed an order. My lord, a recovery notice has been issued. My lord, I have mentioned it last week.
You have mentioned the grounds of urgency.
Yes, my lord, I have mentioned.
Original side mentions you mention at the time of original side because please give it. Yes,
My lord,
yes, Mr. Sanyal.
93.
mentioning a matter for 3
Unless it is taken up by tomorrow.
But on the last week, my senior mentioned this matter, and your lordship was pleased to place this matter in the top of the list.
So it is appearing under the heading urgent only.
But it has been come under 47, my lord.
It is appearing under urgent matters. There are other urgent matters also. I cannot upgrade it to one.
My lord,
It's there. It will be taken up. Yes. দিয়ে দিন to be main দিয়ে দিন
To 793.
to be mentioned দিন ওটা
may I kindly be permitted to mention, my lord, item number 620 of today's cause list, my lords. But on last occasion I had mentioned it, my lords. There's a
it's not appearing as urgent.
No, it's
I said for it to দেখুন এটাও তো রিকভারি নোটিশ গুলো কেন আর্জেন্ট আসছে
What happened, my lord? I have been issued a demand justice of 41 lakhs 20. I have to deposit the same without granting me any opportunity of hearing straightway by the KMD.
Group 1 bench will be available from tomorrow.
But I am paying leave. I am
For
paying
what?
leave to move. Otherwise,
Unlisted, I will not grant.
I am not paying for unlisted.
Then
You kindly grant me leave to move it tomorrow. Otherwise, I
take
cannot.
it tomorrow.
I cannot file it. I cannot file it without.
Tomorrow you take the leave of the honorable.
No, if you also grant me leave, there is a holiday in. That's why I am made. You also kindly grant me
leave tomorrow and file it, sir. Why unnecessary?
You also kindly grant me leave to file tomorrow. That's why I am not paying that.
There is no requirement of leave to file tomorrow. Tomorrow you can usually
if I
file in
file it
usual
tomorrow,
course.
it will appear on. Not be appear before I serve the notice. I am paying for dispense of rule 26 of the read show.
Leave to file. Yes.
But I am seeking leave, my lord, in respect of two items, item 50 and 59.
Now, my lord, this is one matter. Your lordship was pleased enough to grant me leave because of there was urgency. Now, my lord, today morning, this police has assembled around our property and the demolition will be carried out at any time. The difficulty is this, my lord, for today, your lordship is having the determination of group 1. Now, my lord, if your lordship does not take up the matter tomorrow, it has to go back before Justice Bhattacharya. Now, the plight of the petitioner is that, my lord, Justice Bhattacharya will have to release this matter on personal ground because Mr. Shona Bhattacharya.
That I
Lord, your
cannot.
lordship,
I
that is a
cannot-
separate issue.
I
But my
cannot
real
comment
urgency
on-
is this: the police is standing. I will be evacuated any point of time. Your Lord, may I come back at 2, my lord?
I'll have to check it, sir. It's
My lord, your lordship will
there
kindly
are several
understand.
other. I'm understanding there are several other matters that are urgent.
My lord, it's a
Yes.
group 1 matter. My lord, it's
The that matters for petition against your lordship. So such a demand is it cannot be heard tomorrow, but it can be up in the list in the next month.
Yes, it will be there.
my lord will only take it up at 2 p.m. My lord, kindly, my lord.
I can't promise, sir. 2 p.m. there is another matter fixed.
My lord, any time, 2 minutes.
Any
to your
time
lordship,
means
my lord.
what, sir?
What
Any
time,
means
whichever
what?
time.
May
May I- My lord,
I
it's
will
not under
issue
upgraded motion.
Yes, it is there.
My lord,
Always
it is
there.
group 1 matter. It is
Immediately
group 1.
after urgent matters, it's there.
Yes, my lord, I'll
So
sub.
it is an upgraded urgent matter.
My lord, your lordship
Otherwise,
kindly understands. My lord, otherwise,
I am
my
understanding that, sir. If you press hard, it will not help.
my lord, I'm
because I
not
can-
pressing hard. My lord,
I
my lord
cannot
will.
bulldoze all the other matters which have been upgraded and take your matter first.
No, my lord,
No, sir.
3 p.m. before your lordship takes up the original side, may I try my
I
luck? My
can't
lord?
promise. I cannot promise. Let us see how we proceed. Every matter is urgent. Everybody has same and similar pressing urgency. I don't
My
have the right
my
to
lord will
exclude
kindly
one over the
appreciate. My
other.
lord,
No, sir.
regular bench is
Sorry.
not available. My lord,
Sorry,
that's
it's
what-
not that. The bench is available from tomorrow. This bench was also available. I could not
Your
leave
lordship-
because there were other matters
Yes,
which were
your lordship
urgent
was
and
pleased
were
enough
more
to grant
pressing
me
in nature.
leave.
Liberty to mention 6 analogous matters, my lord, for upgradation. My lord, recovery notice has been issued. My lord, may kindly
Give it-
keep
give
this
it-
matter on 5th of January. My
These will all appear in January, not now.
lord.
Yes.
With your lordship's kind leave, I'm mentioning a matter, your lordship. There are actually 2 matters for extension of interim order, your lordship.
Extension of interim order give.
Lordship, the matter is not running in the list, your lordship.
They'll come in the list.
My lord, may I be permitted to mention, my lord, one matter, my lord? My lord,
Yes.
for upgradation, it is running under 365, my lord. The
My lord, may I
urgency
be
is, my lord,
permitted to mention?
only, my lord,
My lord,
only, my lord,
I'm
petitioner
really
is,
sorry, my lord, your lordships. Because of extreme urgency, my lord, fate of the certain students will really go to astray. If your lordships do not take up tomorrow, either pass certain interim order, I will be praying for that, or your lordships hear out this matter. I am almost chasing your lordship because of hearing of this matter. I'm sorry. I know your lordship's hard pressed, but someone has to my lord, hear it out. I do not have any other alternative also. Some protection has to be given to the students. 793. 793
793.
of the hearing list of your lordships.
Seven 9 3 একটু মার্ক করে রাখুন যদি ফাইলটি দেখুন। Mr. Sanjay, please serve a notice on the other side.
Infructuous tomorrow.
Please serve a notice on the other side.
All right. I will do. Certainly, I will do that.
Upon notice and mentioning, on 7th August 2024, an order has been passed by this court, my lord, where addition of party has been allowed, but correction and incorporation has not been carried out, my lord. For this reason, I mentioned, if your lordship kindly allowed to be mentioned tomorrow.
So you correct it if addition of party has been allowed.
Until your lordships extend this order.
What extend the order?
Actually, my lord, can we see this? If your lordship. Para 2, my lord. On the prayer of the learned advocate for the petition, let the national.
So you file an application then and mention it before the appropriate bench. I cannot modify the order of somebody.
But you
That's not
my lord.
for modification.
Lord, may I be permitted?
This is not modification. Only
Yes, it is modification. It is modification. Yes.
My lord, may I be permitted to mention, my lord, a petitioner, my lord, just wanting to opportunity to file the statutory appeal, my lord. Two partners were there, my lord. They were both they are
Very mention it in
fallen
January.
sick, my
January
lord.
it will appear in January.
Lordship, I'm
My lord, it
mentioning
is running, my lord, 365, my lord.
Will be
So
upgraded in
kindly
January.
upgrade.
I've heard.
Okay, my lord, my lord.
Lordship, I'm urgently mentioning for extension of interim order. It is
Please give extension of interim order. Don't mention. Please give the slips. Call Korun.
My lord, may I permitted to mention one hearing matter for inclusion in the list, ma'am?
Please give. Give. Yes. Yes. Urgent matters. Yes.
But may I please do mention, my lord, for upgradation, my lord. The bank has been attached, my lord. I will enclose the documents also, my lord.
Which year?
My lord, MB Ferro and Ilyas Sheikh.
It's there in the list.
Yes, my lord. But the number has been mentioned, my lord.
देखो upgrade
522 and
only 2
236.
days before the vacation. I don't know how many urgent matters I'll take. It will be upgraded.
Yes,
Let us see how I reach.
If it comes, then it's good. Otherwise,
No, it will come because of so many big matters coming in the way. Last 2 weeks, this court was
my lord.
stranded. Every time there is a matter which takes the entire first half. That is the problem. Otherwise, I could have touched a few more matters. This was released.
My lord, it was the WPA number is, I think that should be 2024.
Oh.
My lord, and one more thing, my lord, today, my lord, maybe the order may be uploaded. Otherwise,
Yes,
the
it will be
interim order is
uploaded
expiring
immediately,
today. Expiring in the month of December.
বারবার এরকম ভুল হচ্ছে কেন ওনার? আগেও এরকম ভুল
And my lord, another thing is that the state respondent, this is the income tax matter. The state respondent is appearing.
ওনাকে একটু ডাকুন তো এই এবি কে প্রত্যেক ম্যাটারে এরকম ভুল হচ্ছে। The cost title is correct, only the year is wrong.
Year is wrong, and the appearance is state respondent. The income tax matter, the state cannot have.
Yes. Likhut, this matter has been mentioned for correction. Full stop. The year of the writ petition has been wrongly mentioned in the order dated December 15, 2025. Full stop. WPA inverted comma WPA 1 the expression WPA 15197 of 2025 appearing in the order dated December 15, 2025 shall stand deleted and in its place and stead within inverted comma WPA 15197 of 2024 shall be incorporated.
Great.
Full stop. The other portion of the order dated December 15, 2025 shall remain unaltered. এটা immediately করে দিয়ে দিন, আমি সই করে এক্ষুনি আপলোড করিয়ে দিন। আচ্ছা, the names of the learned advocates since this petition, acha, it has also been pointed out that since this petition na kore, it has also been pointed out that state respondents are not parties to the writ petition, and as such names of learned advocates mentioned as appearing for the state respondents should be deleted. The other portion of the order shall remain unchanged. Should be deleted যেখানে লিখেছেন names of learned advocates appearing for the state respondents না comma as indicated below, তারপরে এটা কপি করে দেবেন এই তনজ এই জিনিসটা স্টেট 1 2 3 আর এটা should be deleted. ঠিক আছে, এটা কপি করে দেন, তারপরে এটা other portion of the order shall remain unaltered.
The order
দেখান, আমি কারেকশন করে দেব দুপুরে, হ্যাঁ দুপুরে দিয়ে দেবেন। টিফিনে আমি গিয়ে কারেকশনটা করে দেব।
Grateful, my lord.
এটা দুপুরের মধ্যে পাঠিয়ে দেবেন যাতে আমি হ্যাঁ। টু কেন দিচ্ছেন?
Lordship, I beg to appear for the petition, Your Lordship, the affidavit of service, Your Lordship.
What is your grievance?
Grievance is the non-providing of the certified copy, which is in page number 9.
Who is appearing for the state?
Lordship,
None appears. You serve a copy on the government legal.
Your Lordship, it was already served and,
Serve a notice at least. They have to come.
Your Lordship, in the
None
previous dates
appears.
also, they did
That
not.
is why I am directing. None appears for the state respondents. Full stop. The petitioner shall serve. None appears for the state respondents. Full stop. The petitioner shall serve a notice on the office of the learned government pleader, intimating that this writ petition shall be taken up next on January 9, 2026.
Much obliged, Your Lordship.
Any affidavit of service filed to be kept with the record of already. Yes.
And I am for the petitioner. My lord, it has come at my instance, my lord. My lord, the interim order is about to expire on December 25.
This matter is appearing. This matter is appearing under the heading extension of interim order upon being mentioned therefore, FOR, FORE no, therefore, full stop. Heard learned advocates appearing for the respective parties. Affidavits filed.
My lord, affidavits are completed.
Full stop. Heard learned advocates appearing for the respective parties. Full stop.
So
The subsisting interim order shall stand extended till the end of February 2026. Full stop. List this matter for hearing in the combined monthly list of January 2026.
I'm grateful.
Grateful, man.
Next date me. Since you put in there,
For the petitioner, my lord.
That's item 7. I appear for the petitioner. My lords, this is also for extension of interim orders. My lords, affidavit in opposition has still not.
Yes, Mr. Chakravarti. When? Likun. This matter has been mentioned. This matter is appearing under the heading extension of interim order upon being mentioned therefore. Full stop. Mr. Chakravarti, learned advocate appearing for the state respondents, seeks some more time to file affidavit in opposition to the writ petition. Let affidavit in opposition to the writ petition be filed within 2 weeks after reopening of this court, after the ensuing Christmas vacations. Full stop. Affidavit in reply thereto, if any, be filed within a week thereafter. List this matter for hearing in the combined monthly list of February 2026. The interim order, the subsisting interim order, is extended till the end of February 2026.
I'm grateful.
Next.
Your Lordship, the matter is for extension of stay. The affidavit in opposition has not been filed.
Yes, Mr. Chakravarti. What about your affidavit? Same order হবে, learned advocates appearing for the respondents করে দেবেন, যেখানে আছে না
wishes to, my lord, in other matters, my lord, extend the stay, my lord, till the disposal of the writ petition. I have the order, my lord.
We're now staying extending till February. We shall see in February.
Because
Yeah,
this matter can be
earlier
tagged.
matters also have done that. Same order kore di. And I'll do it. Appear once again. We'll do.
Yes, sir. And can be tagged with one other matters. my
We'll
lord.
do that in February. Yes.
I'm grateful to your lordship.
Same order, eh? 8 and 9 same order করে দেবেন মানে অ্যাডভোকেটের নাম ছাড়া আর কস্ট টাইটেল ছাড়া
Grateful to your lordship.
But this is my application.
Yes.
My lord, I'm challenging an order of order in original passed by my lord the GST authorities, state GST authorities. My lord, similar matters have been moved before this honorable court. What the authorities have done in the adjudication order, my lord, they have applied a circular with retrospective effect. My lord, the retrospectivity of the circular is under question in a series of writ petitions, batch of writ petitions, where in some of the writ petitions affidavits have been exchanged, and in some of the writ petitions affidavits are pending. This is the order passed in one such writ petition, the lead matter, in fact. Copy the copy the Bohula. I'm seeking an identical order so that my lord, all these matters can be tagged and decided analogously.
Yes, Mr. Chakraborty, since similar issues are involved.
Bohula. Copy print out.
লিখে নিন this writ petition assails an adjudication order
This this Well, this matter was moved on 30th 26 September 2024. Subsequently, that matter was order was passed on 30th September 2024. My lord, the lordship was pleased to directed the respondent authorities to file opposition. Till date, they have not filed in opposition. And what happened in the meantime, my lord? May I hand over the copy of the compilation I have prepared, my lord? विगेंद्र सिंह कहाँ जानी ना
Yes.
Well, kindly see the order passed on 30th September 2024.
30th September, yes.
This
Yes.
My lord, this matter was tagged along with the Baba Loknath, my lord. May I place the Baba Loknath? This is the order. This is a copy, Raj. Why? Order a copy.
Yes.
May I read the? May I read from paragraph 2, madam? The petitioner claimed to be engaged in the business of flour milling industry, which provides service of milling and fortification and packing of wheat and converting the same into fortified atta and packing thereof in usual course.
Yes, Mr. Mujumdar, I've got.
Yes, my lord.
What
Well,
is, you have been protected here. They
yes, my lord, protection, my lord, the 30th September till date, they have not filed in opposition. In the meantime, what happened? The Huldia Commissionerate, my lord, has passed the order in favor in the other assets in the similar facts and circumstances of the case, my lord. My lord, they have taken a different view from the different assessee. For my lord, some has to be one there, but they are not. We basically we are getting refund as per the or we have filed a refund application before the authority concerned. They have issued the show cause notice asking me to. They are raising the demand, but without any basis. But then this is basically, but they have alleged that in the show cause notice there is a suppression of facts, but there is no suppression has not been dealt with nothing nowhere else, my lord. Only saying that this is suppression, only 2 lines has been specifically mentioned and without any basis, Malay, at all.
Yes, Mr.
Well, I have annexed that order passed by the other commissioner in
In the other commissioner, they have allowed the
Yes, my lord.
Mr. Mujumdar, if you have Mr. Banerjee, it has
Page
been allowed
81.
here. What is the
Without any readings, without any claim, this is only with regard to the show cause notice which has been issued in the writ petition. Lordship will kindly see the writ petition and the prayers which have been arranged. To such an extent, Malad, the adjudication order, whatever orders have to be passed, Malad, the honorable court has protected the same. So with regard to any diverse opinion, with regard to other commissioners, that needs to be brought before the adjudicating authority. Because it is the adjudicating authority, Malad.
in this case, adjudication order has been passed.
Well, this, well, I have the supplementary affidavit, well, I was finding this. They have not considered at all, well, nothing. No, this is. आसस तुम बोल रहे जानते हो ना मैं कि तुम
So this order which they have passed, that was brought to the notice of the adjudicating
it
authority.
was subsequently when we invented, but this is there is no question of suppression. In the meantime,
No,
other
no
SSC also.
Yes, Mr. Mojumdar, your affidavit is also not there.
But more than 12, 14 months we have passed.
Over here, the adjudication order will speak for itself. Well, a show cause notice has been challenged, Your Lordship. The adjudication order, adjudicating authority has to decide the same on merits or demerits, whatever is there. So when there is a restraint order with regard to the publication of the adjudication order in terms of the order of the honorable court, it appears the adjudicating authority has
It's already passed the adjudication order.
But it is not being given effect.
Yes, but it cannot be
because of the order.
Yes, madam.
Now, formally, we need to file an application for getting effect.
Only
No,
difficult.
only if the order remains because of the show cause, challenge to the show cause. If the
Well,
challenge to the show cause cannot be sustained, only then you can get effect. If the show cause,
When,
file it, when will you file?
more than 14 months have passed, they have not filed any opposition.
Please
Today
file
they
it,
are
yes.
saying, my lord,
Mr.
unnecessary, we are getting refund more
Immediately
than.
after vacation, I'll be taking this up. When?
After vacation, within 1 week after vacation, we shall file it.
But let them consider the order passed by the other adjudication order in case of other SSC, my lord. Well,
they will come up on affidavit, whatever they have to say. Mr. Mojumdar, learned advocate appearing for the petitioner.
Down, Your Lordship. May kindly take the
An
matter on
adjournment
5th
is
of
prayed
January.
for on behalf of the petitioner.
Kindly see the last two orders passed by this honorable court.
Yes, Mr. Sanyal. What are your instructions?
কি আমাকে দেখা
The main issue was that what was out now. Similarly, these matters. I've been asked to take instruction why you do not just
Mr. Sanyal, share this with him because these are all legal, nothing confidential. Because otherwise he will not be able to answer your charge.
his refund is allowed. And the
Allowed?
refund should be allowed because it appears, your lordship kindly looks at paragraph 11.
Eligible for refund.
They are eligible.
Then what is the problem? Allow it.
Your lordship.
from the order.
Was appellate authority, yes, come up as a challenge against the appellate authority. Now they have seen that after that, because appellate authority in a different case passed a different order, in this case they have passed a different order. So now the department's view is that they should have allowed.
Not a different case, in my same SSC. In case of same SSC, they have passed out. Same SSC.
Where is that order?
Well, ডিফারেন্ট আমি সেটা কি বলবো না সেটা তুই বলতে পারবি অফিসের না সেম সব মামলা কোর্টে আসতে হচ্ছে না
Those are different. Different.
লিখুন
Officers are different. I had a word with him. The officers are different.
For the petitioner. And this is that matter, my lord, which we had mentioned regarding social boycott. My lord, we have served them. Affidavit service. This is the mentioning part, my lord, we had mentioned, and this is the earlier compliance of your earliest last order, my lord, to inform the Pradhan, the Gram Panchayat. That has also been
Your Lordship, I am appearing for the state respondents herein.
Yes.
But,
on the last occasion, Your Lordship, there was a direction to serve upon the panchayat authorities, as there is a issue of boycotting and not giving water connection.
Yes.
And there is this local committee which the police authorities have reported about. And on the last occasion, I have submitted a report which would show, and it was also recorded in the last order as well, that certain amounts were due to such committee, and such committee was willing to give water connection upon payment of those dues. And in that aspect, the panchayat authorities were directed to be served again, and they were directed to come up with valid instruction. But as I can see that the panchayat authorities are today also not represented.
But we have served them, my lord, and pursuant to the report that has been filed by the state, my lord, we have again, my lord, seeking your lordship's leave to file a supplementary affidavit saying that the amount that has been specified is 50% of the total. But if your lordship kindly takes up.
Why can't it wait till after the vacations?
No, my lord,
Immediately after 1 week, what will
yes, my lord,
happen?
your lordship can keep
Because
it. In the meantime, my lord,
necessarily just immediately before the vacations, in the absence of
the Pradhan, yes,
served.
I understand, my lord, but the agriculture season is on, my lord. If I
Okay,
don't
1
get
week,
it,
nothing will happen. We will
but your
keep it on
lordship
the
kindly
5th,
indicates that in the event any untoward incident happened, the police should render assistance. Because
I will keep it on the 5th.
Yes, my lord.
Let it appear on 5th. I am
My lord.
directing the police to ensure the appearance of the panchayat authority.
Grateful, my lord.
Because without hearing them, any
Because we
order-
have also indicated my supplementary affidavit that on the next very day, when your lordship had taken up on the 9th, on the 10th, we had attempted to pay that amount. They are asking us from certain unaccounted amount. Firstly, they are not accepting it. Secondly, my lord, the remaining part, the 11,000 something is the total. Now, my lord, unless and until I get the water connection, I cannot pay. But what my learned friend had earlier submitted, that from 2020 the amount is due. Only amount is due for the year 2020, because thereafter, my lord, no water supply has been provided to us.
Very well.
Your Lordship, since this water supply issue is in the hands of that committee ought to
I've
be
heard you,
added as
heard
a party. Otherwise, the petitioner's grievances may not.
Please wait. Yes.
Sure, Lordship.
None appears for the respondent number 9. Full stop. It is submitted by the learned advocate appearing for the petitioner that notices have been served upon the respondent number 9. You have served the mentioning notice also?
Yes, my lord, everything.
Where do I find that?
But the two supplementary affidavit, two affidavits has been forwarded, my lord.
Yes.
My lord, one is the Pradhan and one is Mr. Tanvir, my lord. Mr. Tanvir has been served by email, and the other one, my lord.
Who is Mr. Tanvir?
My lord, Mr. Counsel appearing for the state, my lord.
No. The Panchayat Pradhan, where is the service on him?
Okay, sir.
You don't have a copy of the affidavit?
My lord, unfortunately, we are not having.
Page 5.
My lord.
Does it show service?
This is the. This is the last attempt that has been delivered. Because today also.
Where?
Well, this one, but we had checked up today also. It's showing the same thing. And no.
Very well, but that will not help.
But in the meantime, then we'll serve this the local police station again.
There is no representation of that. Several notices have been served upon the Pradhan.
But if your lordship take up the photograph.
Respondent number 9. Full stop. There is no representation on behalf of the Pradhan. Full stop. Since the basic allegation also involves the Pradhan, comma, The jurisdictional, who is the officer in charge? Debra?
Yes, my lord. Debra Police
The
Station.
officer in charge, jurisdictional Nagpur, the officer in charge, comma, Debra Police Station is requested to ensure service of a copy of the writ petition
Along with the
along with
supplementary
notice upon the respondent number 9, so that the respondent number 9 is represented on the returnable date, full stop. List this matter once again on January 5, 2026.
But may I have your lordship indulge, my lord, if your lordship-
The petitioner shall forward a copy of the writ petition along with the notice
along with supplementary
and a
affidavit.
copy of this order to the officer in charge, comma, Debra Police Station to ensure compliance with this order.
But supplementary affidavit also will be served upon them.
আচ্ছা আরেকটা একদম উপরে লিখে দিন learned advocate appearing for the petitioner seeks leave to file a supplementary affidavit bringing on record certain subsequent events, full stop. Copy has been served upon the state.
Yes, my lord, we'll serve them again, my lord.
Copies thereof. No, this said supplementary affidavit is taken on record. Copies thereof shall be served upon the respondents forthwith.
Yes, my lord.
Full stop. আর নিচে যেখানে পুলিশের লিখেছেন দিদি ওখানে writ petition along with the supplementary
Yes, my lord.
affidavit করে।
If lordship kindly takes up page 17 of my supplement.
Let it come.
This is closed, my lord. How to serve them again?
Let us see, we have directed the police. They
Lordship,
don't come.
one small thing, if I may indicate, since the main allegations are against that committee, individual committee, if they may be made a party, though that is up to the writ petitioner, but that will
But that is
expedite
why,
the
my lord,
issue.
I wanted to show your lordship the supplementary photograph, my lord.
The Pradhan will not do or Pradhan will do.
Pradhan will do, my lord. The difficulty is this office is 24 hours into
This
7 closed.
committee is of what?
Of the Pradhan. This committee has been constituted by the Pradhan under the government of West Bengal. But the report itself says.
Well, then let the Pradhan come first. If required,
Lordship,
we'll again add
My
the
lord, my
committee
lord.
as party. Yes.
Grateful, my lord.
Grateful.
But in the month of January, my client's, my lord, office has been, my lord, inspected by them, my lord. During the inspection, they, my lord, took, my lord, computer processing unit from my client. My lord, after, my lord, they issue a intimation under DRC 01A to my client. In reply to the intimation, my client said, kindly hand over a copy of the, my lord, that CPU in a pen drive, whereby I can reconcile my statement and, my lord, satisfy the adjudicating authority, my lord, the proper officer. My lord, in spite of such request, my lord, the show cause notice has been, my lord, served upon my client. My lord, in reply to the show cause notice, my lord, again my client requested for the, my lord, the copy of that CPU in a pen drive, my lord. My lord, then, my lord, adjudicating order pass, saying that, my lord, several opportunities was given to me to, my lord, to open that, my lord, the CPU. My lord, and, my lord, the adjudicating demand has been raised against me. Today, my lord, I am before your lordship against an adjudicating order, my lord. Today, I cannot file an appeal, statutory appeal, without, my lord, reconcile my statement. If, my lord, they provide now also the copy of the, my lord, that, my lord, CPU, of the, my lord, content of the CPU, whereby I can reconcile my statement, I can file an appeal with an additional evidence of that, my lord, reconciled statement, and, my lord, the appellate authority can, my lord, taken note of that additional, my lord, evidence, and, my lord, my lord, give me the hearing on the, my lord, in the appellate authority. My lord, I can show, my lord, the order, and, my lord, my first request, my lord, kindly take, my lord, page 70, the order starts, my lord. The detailed order starts. And, my lord, the relevant page is, my lord, page 73. Page 73. My lord, Roman 3. My lord, got it, my lord? My lord, RTP has been given reasonable and sufficient opportunity to reconcile the anomaly found. he failed to provide any satisfactory clarification with corroborative evidence till date. Then, my lord, they goes on, my lord, to explain, my lord, the physical stock of goods. My lord, the RTP in his reply against DRC 01A and DRC 01 only has denied such liability of tax, interest, and penalty as mentioned above due to non-availability of copies of GST and 01. Copies of seized documents and statement of physical stock of goods taken at the inspection on such and seized CPU. But it has not been intimated in the show cause note that CPU and seized document will be returned to the RTP only after disposal of the said seized case. Copy of the GST INS 01 and statement of physical stock may be provided to RTP on prior application before the proper officer. This is to be mentioned here that the RTP has already been allowed to access the seized CPU for providing documents as sought for Annexure A for several times on such and such date, but neither of the RTP produced any document to reconcile the anomalies as mentioned in the seized report nor contacted with the findings. This was also mentioned in reconcile the anomalies as mentioned in the seized report, nor contradict with the findings. This was also mentioned in the show cause notice that the RTP could access the CPU and copy of the seized documents on application before the proper officer. And my lord, kindly come my reply to the my lord, intimation, my lord. That is at page 37.
Yes.
This is the intimation, my lord. And my lord, my reply starts at my lord page 40. Page 40. Kindly take page 42. Minute 2. I deny any consent was given for the seizure or that the representative failed to reconcile the contents of the seized document with records. It was not possible for any person to reconcile the contents of the seized documents with RTP's books of accounts within a period of 1 hour, which is also included search operation. Then, my lord, again, my lord, they, my lord, served me with the show cause notice. That is at page 46. Again, my lord, in reply to the show cause notice, my lord, I requested. Kindly take page 46. And my reply to the show cause notice is at my lord page 55. And my lord, kindly take page 61, where my lord I have in the detailed reply, I have also again my lord I have my lord seek for that. I for the, my lord, kindly take page 61. That is my lord in my reply. My lord, on the my lord fifth line from the top. I further stated that on the 25th January 2024, a report was drawn by the officer of Bali Shalkaja at my place of business. I stated the physical stock of goods was prepared and I had not received any copy of the said statement.
Yes, Mr. Sanel.
Now, my lord, if they my lord, provide me. Yes, my lord. Yes.
I agree with my learned friend is saying that no, you copy and copy and this. But this whole chain of event, if your lordship kindly goes to page 37, starts from the date of intimation. Because in the date of intimation only I can find at page 37, final case. Whereas the RTP in response to his prayer before the proper officer has been allowed to access the seized CPU for producing the documents as sought for Annexure B, which is handed over to RTP at the time of seizure for several times. Your Lordship, we have shown 25th, 25 1, 4 days, 29 1, 2024.
Page
37.
Page 37.
Yes.
Page 37, paragraph 4. Whereas the RTP in response to his prayer before the proper officer has been allowed to assess the seized for producing the documents as sought for Annexure A, which is handed over to the RTP at the time of seizure or several times. This is not a one instance.
Yes.
Various dates are there. After that, he has again, as my learned friend is saying, that reply to intimation, he has again asked for that. Again, in the show cause notice, we have the show cause notice also, your lordship kindly comes to page 48. Paragraph 4.
RTP has been allowed to access the CPU for providing documents as sought for Annexure A for several times. So these are the dates, but neither RTP produced any document to reconcile any documents as mentioned in the season report or contradict with the findings. This is to mention that where the RTP can access the CPU and copy of the seized documents on application before proper officer. So any application has been filed, and if this was the crux of the matter, very well your lordship they could have approached earlier, because 3 times are there. As per my limited understanding, at the intimation stage, only we have RTP saying that you have denied. Then after that comes the show cause stage. The show cause stage is saying that you have added law. Then comes the activity after show cause stage, activation of it. If we have failed to provide any opportunity, we should have very well come approach your lordship at earlier occasion.
I'm grateful, my lord. But access to the CPU is not a handover of the copy of the CPU, my lord. That is, my lord, my learned friend already, my lord, stated, my lord. Access to the CPU, my lord, during the, my lord, in summoning, or, my lord, during the, my lord, hearing process, my lord. It is impossible, my lord, your lordship knows. It's a reconciliation statement, my lord, during the, my lord, hearing process, or, my lord, during, my lord, the summoning process. I cannot, my lord. It is impossible for the, my lord, chartered accountant to reconcile.
There are 4 dates given. These are not during hearing or summoning.
Yes, this is summoning. This is the during the summoning, not handed over to the, my lord, other. This is, my lord, in the on the summoning. My lord representative went there. My lord, they, my lord, just open, my lord, the CPU. But before the officer, I cannot. My lord, I can. My lord, let me, my lord, my lord. He said, my lord, only, my lord, an application has to be filed before the intimation. That is his submission, my lord. My lord, how could I know a process?
Where is the provision for that?
No, there is no provision. There is no provision for the making an application. But how could I know my lord, proceedings has been initiated or not against me? The intimation is the, my lord, the first stage whereby, my lord, I could able
Why
to know.
can't copies be supplied?
Yes.
What is the problem?
No, I am asking for a pen drive copy of the content of the CPU, my lord.
Asking your lordship because he's asking from what I can gather from the orders and the show cause notice, he's asking for access to CPU. And even if we get what all information, because
Where have you said that you want a copy of the CPU?
My lord, kindly take my lord, first, my lord, that is at page 42.
Yes. 42.
42, my lord. My lord, I deny the consent was given for the seizure. It was not possible for any person to reconcile the contents of the seized documents with RTP's books of accounts within a period of 1 hour, for which also included such operation. Then, my lord, kindly take page 44. Page 44. I requested to supply me a copy of the seized records and return the CPU. So, my lord, asking for the.
So you are asking for returning of the
CPU. My lord, seize records and return of the CPU. So, my lord, either, my lord, it is, my lord, the chartered account has written. Today, my lord, I am asking for the, my lord, the CPU. The CPU, my lord, in their custody. And law provides.
Copies of the same can be provided to him or not? Take instructions, come back.
In a CPU, as per my limited understanding, it's a processing unit that part because various other
Yes, by my pen drive.
The relevant information in the pen drive.
What he requires, lordship, I might not be aware. We have to say what all documents he requires.
No, whatever is there can be given in a pen drive.
CPU is an entirely
now, my lord, the CPU is 1 TB and, my lord, the pen drive is 1 TB.
He only wants the soft documents which are. So whether that can be given or not, why not?
Comes to my office, collects all the documents.
See, coming to your office and collecting and reconciling may be difficult with the books. He will have to get copies if those are permitted. If those are not permitted, show me the law why they are not permitted. Because prima facie, it doesn't appear that those will not be permitted. He must have recourse to the documents in order to prepare a defense. Otherwise, how will he defend himself? You come with instructions when?
Wednesday, my lord.
No, Wednesday, please.
Because,
Last day, it's there. Whatever is there is there.
I'm within the, my lord, the period of, my lord, the appeal.
Very well. That is not within, but slightly out.
Within 4 months.
Within 4 months.
3 months and 3 months.
Very well.
And, my lord, kindly
Here, my lord, I am challenging the order in original, show cause notice and recovery proceeding. What happened, my lord?
Long matter, please.
No,
Mr.
no, no, long. Only 2 minutes.
Yes.
Here, what happened, my lord? In
Because
December.
your matters are very circuitous.
Yes, yes, yes. In December 2023, they passed the order saying that no reply submitted. But in the in lieu of reply, show cause notice that was submitted. And prior to that, initial notice, the reply submitted. In the while issuing show cause notice, not recorded, that reply submitted. And in the order, my lord, this is violation of the 73(9) because reply shall consider, and also violation of 75(6). Will set out the fact and circumstances. And my lord, thereafter, order passed on December, and within December, I filed rectification under section 161, saying that proportionate ITC reversal not applicable, such and such, such and such. Thereafter, my lord, in the month of this rectification still till date pending, and March 2025, they recovered around 22% from my electronic credit ledger. Thereafter, my lord, 3rd April, filed the writ petition, my lord. My humble prayer, my lord, let the matter remanded to the adjudication authority for.
Yes, Mr. Baron.
Yes.
2023.
Yes, my lord. Because 2023, but I filed rectification on 21st December 2023. That is still pending. During pendency of rectification application under section 161, they recovered 22% in the month of March 2025. On 3rd April, I filed the writ petition, my lord. Very small factual. Record says, my lord.
6 months normally it is to be done. If there is any inaction, if you very much agree with the rectification in order to avoid that.
What is the rectification that you sought? Where
Yes,
is
my
that?
lord. Rectification application, my lord. I stated in the
show me the
yes,
rectification.
yes.
Don't state.
Rectification page 69, my lord.
Page 69.
69, my lord. That I, such and such Agarwal, partner of such and such, Balurghat, such and such, in our business activity, reseller, not manufacturer. So, Rule 42 is not applicable. That detailed reply, my lord, in the show cause notice I stated, and prior to show cause notice I stated. That was not recorded that I have submitted reply, my lord, in 2 stages in the order in original. Rule 42 is not applicable, that I am not. Rule 42 says, my lord, yes, I am accepting. This is not properly drafted. But my reply.
So what will turn on this? If it is not properly drafted, what will turn on this? Why have you?
My lord, kindly see the order in original, my lord. Kindly see
Show me.
Order in original at my lord page 62, my lord. Kindly have a look, my lord. My lord, the 63 operative part, my lord, main portion, middle portion, my lord. Lordship got, my lord. Yes. The said notice has not submitted any written reply against the said show cause notice. And next page, next para, record of personal hearing. The PH had been given, not attended. PA is not given, and my lord, reply, my lord, page 59. Kindly have a look, my lord.
No, but it says PH has been given.
No, PA is given. They are saying, but no PH notice issued. Kindly have a look, my lord, the show cause notice and my reply, my lord. That will clear, my lord, that no show cause, no PA is given.
Show cause notice?
Yes, my lord. Show cause notice at page, my lord, 57.
57.
Sorry, 55 starting page, my lord.
Yes.
And 57 is, my lord, written that reply has to be filed in within 30 days.
Yes.
3rd para, my lord. And my lord, it is written, which was earlier so, do not appear before the adjudication authority when the case is posted for personal hearing. So case was never posted for personal hearing, and my reply at page 59, my lord. Kindly have a look, my lord. Starting page 59, my lord. And operative, my lord, 60, my lord. Middle portion. Middle portion, my lord.
Yes.
Middle portion, page 60. Sir, our exempt purchase voucher is separate, not combined with the taxable goods. Transport charge included. So, sir, you mentioned Rule 42 is not applicable against our business. Rule 42, my lord, knows, your lordship, that the common ITC reversal for exempt supplied. This is a grocery shop. Taxable purchase, taxable sales. ITC adjusted. Non-taxable purchase, non-taxable sale. So the common. No, but reply is not recorded, my lord. this natural justice violation and also violation of section 73(9).
Why after 1 year if you come?
No, my lord. My lord, during kindly appreciate, my lord. Rectification application I filed within 7 days.
Rectification is in effect rectification on merits, because you say that you have considered the wrong section, inapplicability of the wrong provision of law, or this will require a scrutiny of the entire thing on merits.
Yes, my
Can
lord.
that be done under rectification?
But my lord, my little understanding was
Scope
that
of rectification is very limited.
Yes,
Error
I-
apparent on the face of the
I
record.
am leaving to your lordship, my lord. But kindly see the order. They have not recorded.
I could have interfered after 1-2 years if you come, and I interfere at the adjudication stage.
But,
That
my
is
lord,
your appellate remedy
ye-
is there.
yes, my lord.
I will ask you to approach the appellate authority.
It is incumbent. My understanding, my lord. Eh, No. That is not correct. My lord, I am explaining what happened at the time of filing of the, my lord. We have ticked. If kindly have a look in the backside portal, definitely they will seek yes, because we ticked in the yes and automatically comes no, my lord. This is the general problem faced by the all taxpayer, my lord. I know, my lord. And no personal hearing notice issued, my lord. Record says that no notice of personal hearing.
I'll record all this,
Yes.
relegate you to the appellate authority. You take these points before the
And
appellate
my
authority.
lord, the 22% recovered, my lord. The appeal is 10%, balance 10%.
Where is that? Where is that?
Yes, my lord.
I will say that if more than 10% has been recovered, he will not be required to pay pre-deposit.
Page 73, my lord.
That the appellate authority will verify. If you have, if it is recovered more than 20% or 10% is recovered, then pre-deposit will not be required. I will record.
Yes, page 73, my lord.
Very well. Page 73 you are showing, but I will not be able to understand this. He will understand. I will leave it to
Yes,
him.
yes.
He will satisfy.
But my lord, all my submission, my lord, that they
Yes,
have not
yes,
recorded
yes.
the reply.
If you go on submitting, then I will get jumbled up.
No,
Can
no.
you do that? Yes.
I'm getting.
This writ petition lays challenge to an adjudication order dated, now order in original, dated December 12, 2023, passed by the adjudicating authority under section 73 of the CGST Act, 2017, stroke WBGST Act, 2017. Full stop. Mr. Rai, R.A.Y., learned advocate appearing for the petitioner, submits that the order in original has been passed in gross violation of the principles of natural justice. Full stop. It has been submitted that the reply to show cause that has been furnished by the petitioner has not been considered by the adjudicating authority, and that the adjudicating authority has also not granted opportunity of personal hearing to the petitioner. Full stop. Paragraph. Mr. Rai further submits that the adjudication order has been passed on application of the wrong provision of law, and that in order to get the same corrected, the petitioner had approached the adjudicating authority by filing an application for rectification. Full stop. Keeping such application for rectification pending, comma, the adjudication authority, the respondent CGST authorities have proceeded to recover amounts from the petitioner's electronic credit ledger on the strength of the order in original impugned in the present proceeding. Full stop. Paragraph. Mr. Banerjee, learned advocate appearing for the CGST authorities, submits that this writ petition is inordinately delayed inasmuch as the same lays challenge to an order in original passed on December 12, 2023. Full stop. It is further submitted that pendency of a rectification application cannot be cited as a good ground for the belated approach before this court, full stop, paragraph. Heard learned advocates appearing for the respective parties and considered the material on record, full stop. Since the order in original, which has been impugned in the present proceeding, has been passed as far back as on December 12, 2023, it would not be proper. Now, okay, Teddy. Since the petitioner has an effective appellate remedy before the appellate authority under section 107 of the said act of 2017, this court is not minded to entertain the writ petition at this stage, full stop. However, since it is apparent that the petitioner has approached the adjudicating authority by way of an application for rectification and the same is pending, and since it is the petitioner's case that if the rectification application is favorably considered, the order in original, if the rectification application is allowed,
Yes,
then
yes.
the order
Yes,
in
yes,
original
we'll
will
go, we'll go, we'll go.
Then I am directing them to consider your rectification
Yes,
application
yes,
instead of sending it
yes,
to the
yes,
appeal.
yes.
And the order
Yes,
in
yes.
original.
That are they are incumbent to pass.
Yes. কি লিখলেন দিদি? Order in original may not Not today. Passover. Not
Well, I am
Passover may not be possible
after
because
to come after
2 p.m.
2 p.m.
2 p.m. will be that another matter which is.
Well, will take not more than 5 minutes. Not
They
more
will
than
take
5.
5 minutes.
No, no,
We
no,
don't know.
not required at all.
Because there is a 2 p.m. fixed matter, so it will be only after that. After that, original side will be there.
Well, kindly, otherwise, well,
Passover করে রাখুন দেখা যাক যদি কল হয়. Next.
make it matters 2 p.m.
No, no, no 2 p.m. 2 p.m. are already a fixed matter. It won't look good. Before that
After
fixed matter.
first 2 p.m. second 2 p.m.
If
if it is over, then I will take chance, man. Nothing more.
2 p.m. and if it continues till 3 p.m. then you will lose chance because original side was 2 p.m. 3 p.m. I have a
Then, man, I
deadline.
will take chance, man. That well, kindly 2 p.m.
He's there.
Say. No, no, man.
Oh, he's not.
No, no.
Very, very well. 18 years.
Lordship, Mr. Bharat appearing
May
virtually.
please, your lordships.
Yes.
I beg to appear before the petitioner, lordships. Lordship, this is a challenge to the order passed by the adjudicating authority, where, my lords, there is a consolidated notice and an order passed for more than one financial year. This issue, your lordships are dealing it with one of the writ petitions, my lords. And my lords, recently, the division bench of the Bombay High Court, the division bench of the Bombay High Court at Nagpur, the division bench of the Kerala High Court, the division bench of the Andhra Pradesh High Court, the Karnataka High Court, the Madras High Court have all unanimously have held
খুলে দেবেন এগুলো সবসময় আপনি এইভাবে দিয়ে দেন আমাকে সুবিধা হয়। I'll come back in 5 minutes.
Lordship, please. Lordship, please.
Yes, what is the matter, sir?
May it please your lordships.
Yes.
No, this is a challenge to the order passed by the adjudicating authority, wherein, my lords, my apology.
No, please, I'm sorry. Yes.
My apology, my sincere apologies, my lords.
No, not at all.
Lordships. May I, with my lord's permission? Lordships, my lord, this is a petition challenging the order passed by the adjudicating authority, my lords. For a consolidated period, a notice was issued and an order has been passed. That, my lords, in my respectful submission, is without jurisdiction and cannot be done. As, my lords, the view has been taken now by the division bench of the Bombay High Court and confirmed by division bench of the Bombay High Court, Nagpur bench, a division bench of the Kerala High Court, a division bench of the Andhra Pradesh High Court, my lords, the Karnataka High Court, the Madras High Court, all unanimously have quashed these notices, saying that a consolidated notice cannot be issued and a consolidated adjudication cannot be done, my lords. My lords, your lordships also, my lords, are dealing with a similar matter in writ petition, my lords. I'll just hand over the compilation. My learned friend will just hand it over to your lordships, my lord.
Yes.
That is writ petition number 19573 of 2025 in IVL Dunseri Petrochem.
Yes.
Your lordships have passed an order, my lords. And your lordships are dealing with this issue, my lords. And below that, my lords, I have placed for your lordship's kind consideration a recent judgment of the Karnataka High Court, my lords. It's a detailed judgment running into more than 100 pages, my lords. Then there is a division bench of the Bombay High Court, the Bombay High Court at Nagpur bench, my lords. There is a division bench of the Kerala High Court. There's a division bench, my lords, of the Madras High Court, the Andhra Pradesh High Court, my lords. All have taken this view, my lords. As an officer of this court, my lords, may I point out, my lords, the Kerala High Court judgment has been challenged by the revenue before the Honorable Apex Court, my lords. I must point out. The Apex Court has issued notice. There's no stay, but notice has been issued, my lords. As an officer of this court, I must point out, my lords.
What is the urgency involved here?
My lords, because this is, my lords, we had filed the petition in time. This is an order of January 25, my lords. And we approached your lordships in time, my lords. There is no. My lords, now they were saying that since we are approaching January, they will start recovery proceedings, my lords. Therefore, lordships may protect me. They can file their counter, my lords, in the meantime.
Yes, Mr. Bhattacharya.
Yes, right from your lordship, first in this case, the compilation my landed file, my lord, that we are trying to find out, these are all challenging so-called states. They participated in the adjudication, didn't raise any fees per year. And my lord, already ordinary original has been passed. That apart, Delhi High Court, my lord, division bench also approved that multiple or consolidated shokas can be issued, my lord, because Section 74 does not bar the authority to issue. There is nothing, my lord. Therefore, maybe there is different judgment of the another High Court, my lord. I am saying, my lord, in when they filed the reply, they didn't take this point. It's an appealable order. Why they come after later, my lord, though it hasn't filed after long before. That apart, well, they challenge the notification of 11, by which, my lord, they are trying to, my lord, challenge the constitutional validity.
Yes, Mr. Rachandani, he is right, because the cases where I have intervened are all at show cause.
May I just submit, my
I
lords?
was shown an order of this court where this court had refused to intervene because an order had been passed, an adjudication order had been passed, and that was the ground on which the earlier cases were distinguished. Now, the Bombay High Court, Kerala High Court, they may be persuasive, but they are not binding on me. There is no. So this point can be considered, but at this stage, I am not minded to pass any interim order. And
May I
you can
just
always
submit,
come up
Milords? I'll come up before you, Lords.
because see,
Just one.
before the vacation, I will not go into a lengthy hearing on this.
Certainly, my lord, certainly.
I can post it immediately after the vacation.
Lordship may
And
do
if
that.
you want,
Lordship, I'll be obliged, my lords. I'll be obliged. But may I just assist the court, my lords? These orders, your lordships are right, my lords. The other courts have taken a view. They are certainly of persuasive value. Courts have intervened at adjudication stage also, my lords. I'm making a statement
very
as an
well, they
officer
may
of this court.
intervene. There are counter arguments also. There are
Certainly, my
orders
lords.
which are
Certainly.
there are orders which are holding contrary to the views taken by the Bombay High Court because there was a Delhi High Court I was shown that is noted in my order also. So it
Lordships,
is
the
not
Delhi
that
High Court, may I just assist, my lords? The Delhi High Court has been considered by the Bombay High Court, has been now considered
doesn't lead to anything, sir. Doesn't lead to
No,
anything.
certainly. Your
Bombay High
lordships have
Court
to
may have
decide.
considered Delhi and may have taken a different view. I may consider
Certainly.
both and still take a different view.
Lordship,
So
I'm
therefore
in my
that
lord's hands. Certainly, my lords. Your lordships have to decide. I'm
so
just
therefore,
placing this.
Mr. Raichandani, let us not waste time on this. I will not grant
Lordships.
interim order if you want. I can spell that out, or if you want, I can post it immediately after the
Lordship may
vacations
post
and
it
take it.
after the vacation, my lords.
Very
I'll
well.
assist your lordships. I'll
Let us
come
not
physically also, my
unnecessarily
lords.
argue on this because
I'll assist your lordships physically, my lords. I'll come there. Lordships may post it beyond vacation.
Very well.
Any date
Heard,
convenient to your lordships post
heard
vacation.
Mr. Raichandani, learned advocate, appearing for the petitioner, and Mr. Bhattacharya, learned advocate, appearing for the CGST authorities. Full stop. List this matter. When do you want? Tell me.
Subject to your lordships convenient any time after vacation, my lords.
Yes, we are reopening on 2nd.
Any Friday, if I may pray, my lords, I'll assist your lordships physically.
Fridays will be a different day for the court because we'll not be taking group 4 matters. These belong to group 4.
Oh, I'm so sorry. I'm so sorry, my lords. My lords, I apologize. I was not aware. Then, as per your lordships convenience, lordships may fix. I'll come, my lords.
It will be Monday. It will be better on Monday, my lord. Any Monday morning after vacation, lord. Morning.
Can we have it on 14th?
Lordship pleases.
14th.
Lordship pleases. Lordship pleases.
Thank you. Yes. Oh, Mr. Dutt for the Union of India, Okhandi.
Grateful. We're obliged, my lords. We're obliged.
Thank you very much.
Grateful.
But Mr. Sanjay is appearing for the CGI in the
I'll give it. Yes.
Well, after the petition,
My lord, I prefer not today. My lord, I prefer not today.
Why?
Somen Bhattacharya is appearing, my lord. I think my lord, he's on his legs in court number 759. I'll make it not today.
Not today. Not
He
today.
is facing difficulty.
Not today. Not today. Next.
Well, in this application, well, I'm challenging the impugned adjudication order as well as the rectification order. No, what happened? The Honorable Supreme Court has passed a judgment in case of Mohit Minerals matter. It is no longer res integra. There is the IGST on ocean freight cannot be leviable. The notification issued in 2017 has been struck down. It declared ultra-vires to the Constitution. Even assuming that the adjudicating authority saying that it should be.
Yes.
The adjudicator is saying that the judgment passed by the Supreme Court, it cannot give in retrospective effect.
Yes,
But
Mr.
it is.
Sanyal, you are appearing.
Make it not today. Who is appearing? Let me check.
Not today, Korera.
This is
next.
21. My lord, item number 21, my lord, I'm not ready. I will do number tomorrow, my lord.
This is a covered matter covered by your lordship's order.
What
My
is
lords.
that?
I'll not hand it.
Tomorrow.
My lords.
Grateful.
Much.
Not today. Mr. Bhonjo is very fair. There are very few CGST councils who
He's
fight.
absolutely prepared. I mean, I have told him that he's one of the few councils who absolutely comes prepared.
May it please, Your Lordship. We are for the petitions. Well, this is one of those matters where notifications enlarging time under 160 capital A of the CGST Act is under challenge, my lord. We are ready to put in 10%, my lord. I have one suggested audit, my lord. Now. Suggest. These are with pencil corrections.
Depositing 10%.
Well, only one indulgence, my lord. There was a notice of 21st July. Kindly, my lord, along with the impugned order, notice of 21st July 25. Last week.
Order dated August 2, 2024 and
Yes,
21st July.
Yes. Recovery notice dated 21st July 25. Kindly stay that note. In the last paragraph.
The last paragraph will suffice.
Will,
shall be restrained from recovering any sum.
Just since the notice is just this much, my lord. Just this much.
Because this covers.
Well, I agree, my lord. This is for the purposes of the officer. There are some issues materialize only this much. My lord, may I have that notice also.
Page. So because this notice is not a part, even in that matter, I remember something was handed up. I'll indicate that.
Yes, but only this much. Connected recovery notice. That is all. Just this much.
এইটা কপি করে নেবেন।
of pre-show cause to the order, it is completely in violation of principles of natural justice. Your Lordship, in this case, what had happened was that I received a pre-show cause notice in DRC 01A. I give them a detailed reply. They don't consider my reply. They straight away issue a show cause notice without even considering any of my reply. Then in show cause notice, I reply, I give a detailed reply. They don't consider it, and in the order stage, they add on 2 additional grounds which was never a part of the show cause notice. In order, it's a recorded fact that after I had submitted my reply, they conducted further investigation. Now, Your Lordship, it is a settled principle, Your Lordship, that show cause notice itself is the end of the proceedings. It inculcates into a show cause notice. In the instant case, that has not been done, Your Lordship, and this is also in clear violation of section 75(7), Your Lordship. Now, may I place facts? May I place the documents?
Yes, Mr. Sanya.
Lordship, during what my learned friend is submitting, during the course of submission, what he replied, considering that replied only a new fact came into picture. Let my learned friend.
No, but if a new fact came into picture, then in that case he ought to have been given an opportunity to traverse that.
Nothing substantive came into picture. Only the vehicle number, because regarding this show cause notice, this regarding that you are from non-existent supplier, you are availing ITC. So regarding he submitted a reply. So after that, it's not particularly, I cannot say also new fact also, but no moment, if I may present the fact, Your Lordship, because it's enmeshed in the fact only, I have to present the entire fact. So let my learned friend start. Your Lordship, I will.
Don't go into long drawn arguments today, because these are all.
Because no urgency. First of all, Your Lordship,
No, there is
adjudication
what is
order.
the urgency? Recovery. Your Lordship, we have been issued with a recovery notice, Your Lordship.
February 27th, February is the adjudication order. Very well, they can take all this.
We have affirmed
for the appellate authority.
Your Lordship, but there is a violation of natural justice, Your Lordship. Will kindly see.
When was the adjudication order?
27th February.
27th February, Your Lordship.
2025.
And we have filed the writ petition on 23rd of May, which is within time, Your Lordship.
Filed it within time.
Within time they have filed, but Your Lordship.
Yes, show me the order.
Your Lordship, the impugned order starts from 44. The detailed order, Your Lordship, starts at 49.
49.
वो दिखा रहा है डिटेल में वो टेबल भी दिखाया है टेबल.
Your Lordship will come straight away to page number 53 of the petition, Your Lordship.
53.
This is a summary of my demand. So ITC uploaded by supplier whose registration has been cancelled retrospectively, that is cancellation date is earlier than the invoice date. This is number 1 allegation. The second allegation is ITC found reversible in respect of credit notes. And third, Your Lordship, is ITC found reversible in proportion to exempt supply. Now, Your Lordship will kindly come to the show cause first as to the pre-show cause first as to show that my reply has not been considered at all at the pre-show cause stage. Now, in this aspect as well, Your Lordship, there's a judgment of our very division bench which states that if an adjudication order, subsequently if an adjudication order is passed without considering my reply to the initial DRC 01A, then in such a case, the adjudication order is to be quashed, Your Lordship. It is a settled. I'll show you the judgment as well. Your Lordship will come to page number 20, Your Lordship. I'll read it out from paragraph number 3, Your Lordship. The appellants were issued a pre-show cause notice under section 73(5) of the Act dated so and so on the allegation that the appellants had claimed ITC against supply received from non-existent RTPs whose registration has been cancelled. The details were enclosed in the annexation to Form GST DRC 01A. The appellants, on receipt of the pre-show cause notice, submitting their reply dated 6 October 2023, among other things, they stated that they have effected purchases from 3 enterprises and all the purchases made were properly accounted by them and claimed ITC as when shown in GSTR 2A. And they have also cleared their account through bank payment, and the details thereof were attached to the reply. Same as in my case, Your Lordship. The appellants further stated that they are enclosing all the copy of tax invoices, EVA bills, along with copy of Kata slip, bank statement, copy of ledger books. Further, with regard to the cancellation of the registration of the suppliers, the appellants contended that they have made the purchases from those parties at the time when their registration were active valid. The appellants referred to section 16(2) of the Act, which stipulates the conditions for availment of ITC, and they submitted that they have complied with the requirements by producing the tax invoice, debit note, or other tax paying documents, and they have received the goods, and the tax charge in respect of such has been actually paid to the government. Further, they submitted the details seen in the GST portal. With these submissions, they requested for that the further proceedings in the pre-show cause notice may be brought. The authority appears to have not been satisfied with the submission made or with the documents which were enclosed along with the reply to the pre-show cause notice, and proceeded to issue the show cause notice dated so and so, reiterating the same allegation as contained in the pre-show cause notice. Same here as well, Your Lordship. The assessee uploaded the reply to the show cause notice on 26 February, reiterating the earlier reply, and submitted that they have purchased goods from local dealer, cost of material goods is inclusive of freight, and that they do not provide any expenses as carriage invoice, as it is included in the cost of the goods. Thus, what was required to be considered by the adjudicating authority is whether the assessee had complied with the requirements under section 16(2) of the Act. The adjudicating authority passed order under section 74 of the Act on 10th of July. On perusal of the same, we find that the adjudication authority has not dealt with the issue as to what would be the effect of retrospective cancellation of the supplying dealer on the claim ITC made by the purchasing dealer. Secondly, the assessee specific case that they have established the movement of goods by procuring all tax invoices, copy of...
Show me your case. Where is the pre-show cause notice?
Your Lordship, the pre-show cause notice is at page number 71. The detail starts at page number 74.
And where is your reply to that?
My detailed reply, Your Lordship, it starts at page number 85. I'm just, Your Lordship, referring to the point wise which I have replied. Reply to point 4A, Your Lordship. This is at page number 87. This is with respect to the retrospective cancellation of my supplier's registration. I have also submitted, Your Lordship, the relevant documents, the bank recovery documents of the supplier, the purchase bill, invoices, tax invoices, EVA bill, payment details, along with the ledger, as well as the GSTR 3B of my supplier. And they have also filed their return, Your Lordship, and paid the tax when they had filed their GSTR 3B return. Then I also replied to the second point, which is also at page number 89, Your Lordship, where I said that the difference is due to I have claimed less as to what was available to me. And I've also replied to point 4E, Your Lordship, which is...
How has this been considered?
Your Lordship will kindly take volume 2, Your Lordship. The show cause notice is in volume 2.
Page 211 is the show cause notice.
The relevant part, Your Lordship, starts from 216 of the show cause.
211. Yes.
200, Your Lordship, will directly come to 216. I read out, Your Lordship. Whereas the table in attachment 1 to ASMT 10, detailed working whereof as given in Annexure 2, shows that the summary of discrepancies noticed during the scrutiny of returns furnished by you with reference to the information available, if any, in your GSTR 1, 2A, 9 and 9C for the period 1/4/2020 to 31/3/21. Proceedings under section 61 of the CGST Act, WBGST Act, was initiated bearing case ID so and so dated 12/7/24. In response to whereof no reply has been submitted. This is with respect to my scrutiny assessment. Now, Your Lordship, the intimation of liability was issued through DRC 01A with reference number so and so dated 5/9/2024. This is the pre-show cause notice. Regarding ITC uploaded by suppliers whose registration has been cancelled retrospectively, cancellation date is earlier than the invoice date. Upon verification of the official database, the following points have been observed. He has just reiterated the points, Your Lordship. There is no consideration of my reply to the DRC 01.
Lordship, kindly sees paragraph 4 because that will be relevant in...
I have replied to that. I have replied to this in the show cause notice itself. Well, I replied to the show cause notice because this allegation was also not in the pre-show cause. I've also replied to this allegation as well, Your Lordship, when I replied to the show cause notice.
And how has your reply to the show cause been dealt with in the order impugned?
Your Lordship will take the order.
Page 49 is the order included.
Page 49, the order starts, and page number 58, Your Lordship, the reply of the RTP and the inference thereof. How is he dealing with me with my reply? Your Lordship, the RTP had submitted his reply against DRC 01 in response to the reminder number 2 in the portal on 6/1/2025, again claiming the genuineness of the transaction and goods movement, and the same written reply has been submitted in hard copy. But no movement details such as consignment road challan, transportation payment details with reflection of bank transaction, payment slip, the details of outward supply of the purchased goods have been provided as for in the show cause notice in DRC 01, except the invoices and bank statement and some details of the concerned supplier. Upon going through the submitted reply, it reveals that the RTP has tried to establish the whole transaction of the goods having HSN 39206929 as a common business practice for cost effectiveness, but in spite of providing ample opportunities, no above mentioned transportation documents, goods received note against transporter copy, the outward supply documents against the dubious inward supply, and the supplied goods bearing same HSN and the circular trading have been provided against the various transactions the RTP mentioned in the show cause notice. Analysis. It is pertinent to mention here that without corroborative evidence from the part of the RTP regarding the fate of the purchased goods and the subsequent tax payment against related outward supply, the actual motive of the trade cannot be established. Again, this is relevant to mention here that the burden of proving the ITC claim is correct lies upon the person claiming such ITC. Burden of proof that the ITC claim is correct is squarely upon the assessee who has to discharge the said burden.
He has I've seen it. He has dealt with your objections.
Your objections, Your
Your Lordship, kindly will come to page number 59, Your Lordship.
I've seen page 59.
Your Lordship, this is important because, Your Lordship, to verify the genuineness of the submitted documents and the claims made by the RTP in the submission, the undersigned proceeds to investigate further into the matter. Now, my humble submission, Your Lordship, is that once he has issued me a show cause notice, the investigation thereof has been concluded and has inculcated into a show cause notice. If
investigation, it's a wrong usage of English because of their
verification.
Further into the matter means he is going to examine it in detail.
Even then,
that is clear. That is clear from the subsequent paragraph.
That's what I was
it's not that he has undertaken a separate inquiry.
That's what I was submitting. Your Lordship,
investigation is a word of many hues, many colors.
Your Lordship, he proceeds to Your Lordship, he proceeds to rely upon statements of 3 transporters. Now, I was not provided with the copy of the statements of these transporters. Neither was I benefited with an opportunity of cross-examination, which I anyway couldn't have.
From what I can gather.
No, but if you are relying on certain transporter statements.
He submitted few documents. Based on that, during verification, these all transporters' name came up. And if Your Lordship kindly see from page 59.
It's not on his submission. If we read page 69, in response to the summons issued to the vehicle owners.
Yes,
the vehicle owners appeared before the undersigned, and in some cases summons were non-communicative.
Lordship, if I may read, upon analyzing and verifying the submitted e-way bills to Vahan portal and the details, we have generated and some suspicious observations regarding the vehicles.
You read page 59.
59. I'm reading from 59.
Read second paragraph, second last line.
The vehicle owner. Second last line. Apart from there is a gross.
No. Second paragraph at page 59. Second paragraph begins with upon analyzing.
Upon analyzing, I'm reading that.
You read the second last line. In response.
Response to summon issued to the vehicle owners appeared before the undersigned. So, Your Lordship, there is a thread. What I am trying to establish is that they had.
Very well. If you have taken into consideration the evidences of certain persons.
Because based on their documents, we have.
You have issued summons, you have called those persons, you have taken their depositions. If those depositions are relied on for the purpose of arriving at a conclusion, then in that case, they should be given an opportunity to cross-examine that, because these are adjudication proceedings.
Lordship, kindly send them back, because
sending them back will not do.
Because they will
I will have to hear this out. Because at this stage only I will not. Let us see what is the evidentiary value of this, whether cross-examination was at all required or not. At the moment, you have proceeded for recovery.
Yes, Your Lordship.
Regarding recovery, I don't have specific instructions, Your Lordship. They are because they have not brought in record also, the recovery proceedings. They have to bring in because until unless they are recovery শুরু করেছে কবে? When did they send you? Lordship, kindly allow them to file a supplementary affidavit then.
Okay. This is only a reminder.
Final
This is
reminder
only a
for payment
reminder.
of outstanding.
Hmm?
DRC 13 days, not DRC 13, Your Lordship. Not DRC 13.
You, I am keeping it immediately after the vacation. I will also go through it. If in the meantime they start proceedings, you come up, it will be appearing as an urgent motion only. I'll hear it out because before the vacations, entering into these long drawn matters.
Because this will,
affect
because this is
other matters
completely,
also.
because what I
Well,
can
ca-
gather,
kindly
Your
bring
Lordship,
up
the next date of
next
hearing
date
at
of-
least protect us.
No,
Till
no,
the
no,
next
there
date,
is
no
no
protection
there's no
required.
attachment notice as
There's
yet.
no DRC
I would
13
have
has
not
been-
brought it under the heading urgent motion if this was
There's no note.
liquid. Heard learned advocates appearing for the respective parties. Full stop.
Lordship, we are challenging the appellate order that was passed on 24th February 2025. That is on page 95, Your Lordship. And the demand is of rupees 68 lakhs 4,061 rupees, Your Lordship.
What is wrong with the appellate order?
Your Lordship, here it is given that the ITC has been rejected on the grounds that the supplier has been retrospectively cancelled, Your Lordship. Your Lordship, there is a judgment by Supreme Court which is yet pending that the RTP cannot be held liable if the supplier has not filed.
That is the only ground.
Here, Your Lordship, there is
Reply
another.
has not been considered and those standard grounds are there, Your Lordship. It requires hearing, Your Lordship. This is not, because the
Mr. Mojumdar, any notice has been issued of attachment? Because prior to the vacation, only those matters, because there are matters which require urgent hearing.
This matter only, matter can.
I'll keep it as
Subject to-
urgent motion
must
only
subject-
as the other matter.
I'm saying, all the 5 points are involved in this petition. Minor can admit the writ petition by asking the petitioner to pay 10% of the disputed demand.
Likhen. This writ petition lays challenge to Yes, Mr. Raju.
By this writ petition, I have challenged an order in appeal and an order in original arising from Section 73 of the GST Act. Malad, the order in appeal has rejected my appeal against the order in original on the ground of delay. Malad.
How many
And
days?
Malad, over 11 months. 11 months. Over 11 months. Malad, and it falls under those category of cases where the pre-show cause, show cause, and the order were uploaded under additional notices and orders tab. Milad, I'll just mention that I have given reasons. Okay, I'll just briefly mention the issue because Milad, for a subsequent period.
There is an order passed. You
Yes,
have
Milad,
that?
I have. Milad, this is actually factually in my favor. I'll just bring one small point. Milad, the issue that has been raised in these proceedings for financial year 2018-19 has also been raised for financial year 2021 at the stage of adjudication. Milad, over there, they have heard my reply and dropped the demand.
Very well.
Yes.
You will go back to the appellate authority and raise the issue.
Yes.
Because order also is dated 29/1, 2024. That was the period when GST
When
portal
this problem was there.
problem was there.
You have the order so that.
Yes,
it can
Milad,
be
I'll
easier.
just. Milad, two orders I place before your lordship. Milad, in the first case of Birla Brothers Private Limited, Milad, same that it was uploaded on the portal under additional notices and tabs. And Milad,
Multi-reach.
yes, Milad, multi-reach. Milad, paragraph 9 is in Birla Brothers. Milad, in multi-reach, Milad, in paragraph 7, Milad, your lordship has heard that Milad, that there was a problem. And Milad, subsequently in paragraph 7, another judgment has recorded. In paragraph 8, Milad has passed the order. And Milad, one last point I'd like to make very quickly. Milad, over in this
Not
case,
required. I'm sending you back to the appellate authority.
Milad, it has to go to the adjudicating authority. Why I say this is
You have filed the appeal before
Yes.
the appellate authority.
Yes.
That has to be revived first. I will not decide the appeal now.
Yes. Milad,
Because if you had not filed the appeal, you had come up, then that was a different thing.
Yes.
Let the appellate authority decide it in accordance
Milad,
with law.
if I can just say one point
Not
is
required. Before the vacation, Mr. Raju, have it before the appellate authority. You had chosen if the appellate authority had decided it.
Yes, Milad.
You would have not come here.
Milad, appellate authority cannot correct the wrong.
The jurisdiction of the court is limited now because it has been dismissed on the ground of delay. I will not enter into merit.
I understand.
I will be satisfied with the delay, set it aside, restored.
Yes.
Then
Much obliged.
my learned friend will get another opportunity to come here.
The
Medical reasons. Condonation delay, my lord, page 102.
Yes.
My lord.
Where is the year?
Adjudication order, my lord.
No, the condonation of delay.
102, my lord. Here written 62 days after 3 months, but 32 days after 3 plus 1 month.
So total 62 days. Medical reasons are also there. Listen. This writ petition assails and order dated or date of the order is
Date of order, my lord, page 85, my lord.
no. Appellate order state.
Appellate order, my lord, page 110, my lord. 26 June 2025.
Order dated June 26, 2025. Passed by the appellate authority under section 107 of the WBGST Act, 2017, stroke CGST Act, 2017, whereby the petitioner's appeal against an order dated,
my lord, adjudication order, page 85, my lord, 7th August 2024.
Order dated August 7, 2024, passed under section 73 of the said Act of 2017, has been dismissed on the ground of delay. Full stop. Paragraph. Mr. Rai, learned advocate appearing for the petitioner, invites the attention of this court to the application for condonation of delay. Where is that?
102, my lord. Relevant para, my lord, 234.
To the application application for condonation of delay filed before the appellate authority within bracket at pages 102 to 104 of the writ petition, 105 of the writ petition, 5 no, 6, 7, 107 of the writ petition, and submits that the petitioner could not file the appeal within the time prescribed by the statute, inasmuch as who was ill, the petitioner himself.
Both petitioner, my lord, there are two partnership firm, and looking after the partner, my lord, that partner paid 104, my lord, medical documents. 4 to 6. 4 to 7. 4 to 9. 104 to 9. 109.
Inasmuch as one of the working partners of the petitioner was seriously ill, full stop. The appeal has been filed by the same partner who was ill.
I'm checking, my lord. Praying a moment, my lord. Chanda Construction, Bharati Chanda. Bharati Chanda. He is, my lord, signing partner, because in the GST portal one have to show the signing partner, and he is, my lord, she is, my lord, looking the GST matter, my lord. Signing partner. দুজন signing হয় না।
The partnership firm, your lordship, translating.
One of the partners, working partners of the petitioner. No, one of the working partner of the petitioner. The working partner of the petitioner firm. The working partner of the petitioner firm was seriously ill. Full stop. Documents in support of the illness of the said partner have been annexed. Have also been annexed to the application for condonation of delay. Full stop. Paragraph. It is noticed that
Considering on the last occasion, my lord is pleased to pass an order direct to the respondent authority to take instruction.
Yes,
Whether
yes.
they
Yes, Mr. Sanyal.
Your Lordship,
He is agreeable to pay 10% removal of blockage.
I have received instruction, Your Lordship, if the RTP deposits, as per his declaration, 10%
বলুন রেকর্ড করা আছে তো কোথায় ভুল করে বলে ফেলে
20 lakh. If RTP deposits 20 lakh.
20 lakh.
As
20
per his
lakhs is more almost 57 lakhs is the demand. But the
Because
rule 86
petitioner
was
purported-
introduced for the purpose of the protection of protection of the revenue, my lord. The
Mr.
rule
Mr. Majumdar, what is the challenge here? Adjudication
What is
order
the
or appellate
credit,
order?
my credit ledger has been blocked on 4th
No,
of
no,
March
the
2020.
challenge is what? Adjudication order or appellate order?
No adjudication. There is no adjudication order.
Why is it blocked?
They are blocked. They are saying that there is a evasion of tax of 57 lakhs. They have determined.
For
Final, they are asking me to deposit. They are on the private basis. They are determined there is a 57 lakhs. There is a evasion of tax of 57 lakhs only. So I am ready to pay 10% of the disputed tax. Mana has recorded in paragraph 2 of the order dated 16 December 2025. My submission of your lordship is that they have conducted search and seizure in the month of January 2025. They have blocked my credit ledger in 4th of March 2025. We are into December 2025. They have not done anything. Well, my books of accounts, everything, all records had been seized by them. They are holding all documents. I could not run my business by Sunday creditor, everything. Well,
As
they,
per law 86A, before initiation of any other proceedings, for 1 year, period of 1 year, they can block.
well, they can block, they cannot, they cannot seize my documents. They have to supply me the documents.
But they have challenged the negative blocking.
I'm also challenging, challenging the action of the respondent authorities, not only the negative blocking.
86A of what?
86A of the rules, Your Lordship.
Rule 86A.
Rule 86A.
Well, is not
and
the
which has been
act,
approved
madam.
by this court, division bench of
Well, other high court, even the Supreme Court has granted stay.
are
Then
approved
I'll
by
have to hear it out.
but show is the judgment.
Well, only difficulty is there, my lord. They cannot be sit in tight. Well, this is the
No,
authority,
I'll
my lord.
hear out one way or the other.
Well,
Lordship,
only submission, lordship. I am already offered 10% of the disputed tax. Kindly give me give me some installment so that I can pay 10 lakhs rupees.
Mr. Majumdar, then
I cannot run my business. These things going
for
on.
1 more week, you suffer for 1 more week.
Yes.
I'm keeping it on 5th or 6th. I'll decide it.
Because Your Lordship,
Be ready, I'll hear it.
because I have received instruction on instruction I'm speaking.
But they are ready to take.
Amount, what he is saying the amount, that is not the amount of evasion.
No, I am not saying, I am whatever.
They are calculating as per the evasion.
How can you determine the evasion of tax? Although they have written, kindly come to page. It is their document. I am not saying this is my document.
Kindly fixes it up.
No, kindly, the document is apparent from the record. I am not saying on my own.
Page?
এটা পেজটা বলতো 57 লাখ যেখানে দেওয়া আছে না এটা final computation page 40, my lord. You start from page 38, page 40. देख
40,
page 40, last.
What is this? I mean, it is half.
56 lakh and odd.
Yes, my lord.
39. Lordship, I am not aware of what is this document because 39 from page 39.
দেখে বললি আগে দিন সাবমিশন করে 10% ইনস্ট্রাকশন নিবি এখন বলছি জানিস না communication of disalliance of debit from the credit ledger in accordance with rule 86A. But they are saying, I am not saying that while they are blocking my credit, it's reflected from their order itself.
I am hearing it out. I'll hear it out, Mr.
Well, in the meantime, maybe the document may be released. Well, my credit, everything I can, my business has been standstill. Well, it is specific.
Ask me to get instruction how much amount is required.
Very well, Mr. Majumdar.
Well, it is recorded, my lord. What my understand said, I am disagree with that. Kindly see my paragraph 3, my lord.
The documents might be direct.
Well, this is there, my lord.
Very well.
I couldn't run my business from March
today let the status quo remain for one more week. Let me apply my mind to this. After the court reopens, we'll because now in this hush hush, I will also not be able to apply my mind. Something wrong might happen. Let us see. For one more week, you. I'm fixing it on 5th.
He's on the top of the rule, man. Otherwise,
Either disposal or at least interim order, whatever. Heard Mr. Mojumdar, learned advocate, appearing for the petitioner, and Mr. Sanyal, learned.
One mentions yesterday, Friday, the item number 624, we appeared for Union of India, but some reasons or other that was missed.
That is not reflected in the order sheet by the
What?
lackadaisical approach of the or inadvertently court
What
officer.
has not been reflected?
16 names.
Has not been reflected.
Your
That
name.
is not been recorded.
Appearance has not been recorded.
Appearance has not been.
Correct. To be mentioned, they were there. I have.
My
To
lord,
be mentioned for correction.
Item of 50 and 8 and 59, my land matter, my group 1 matter, just mentioned before your lordship, today, my morning.
What is the urgency? What has happened?
My predicament is that the notice has been issued under section 4C5, and no hearing has been granted.
You can bring your other side.
We can bring my other side.
So let us see. There is a fixed matter at 2. After that, if we have time before the original side, otherwise bad luck.
my lord,
Lordship will try your.
my lord, item number 31, my lord, that can application for the stock release of stock, my lord, it will take only 1 or 2 minutes, my lord.
Very well. So it's almost there.
Yes, yes.
If not today, tomorrow it will.
Yes,
be.
yes, my lord. I'm good.
My lord, item number 28,
What
we have mentioned for withdrawal of the case.
You are there. I'll be calling. You are there. Your other side is there. You want to withdraw it.
Yes,
You
my
have your
lord.
letter ready.
Yes, my lord.
Give me. शेष कर दिया.
I mentioned
Mentioning slip now or withdraw করবে তো.
my lord.
Yes. You are the advocate on record.
No, my lord.
Who is the advocate on record?
My senior.
My lord, I'm appearing virtually, my lord.
My lord, I am for.
And Mr. Bhaskar Singh is the advocate on record.
You don't want to continue with this.
No, my lord, as the order has been passed, my lord. That's why the
learned advocate appearing for the petitioner hands up to court a copy of a letter dated December 19, 2025. But this has been addressed to court. This is not how you write. You bring a proper letter, it will appear as for withdrawal tomorrow.
Careful.
It should be addressed to you.
But I have faced the situation in the taxation tribunal, my lord. Some client has written to the court only.
One matter, my lord, one matter, my lord. I filed it on Wednesday, my lord. My lord, the bank has been attached, my lord, for a long time, my lord, near about 7-8 days. My lord, if I get the number, my lord, I'm not getting the number, my lord, if I get the number, can I?
Very difficult. Before vacation, let us see.
Did.
তো টাইপ করিয়ে দেবেন তো, এইভাবে দিলে কি হবে? টাইপ করে দেবেন, না নষ্ট হচ্ছে না।
This matter.
As my learned friend had cited the judgment of the Honorable Supreme Court in the case of Amitabh Bachchan, but his argument had been that he has the power to call for and examine the record, and also that he has the power to cause inquiry to be made. That was basically the submission on behalf of the respondent. Now, kindly have a look at the decision in Amitabh Bachchan. But that was a case where there was a show cause notice issued. In the show cause notice, certain issues were raised, but in course of the order dealt with several other things. It was found that in respect of the other things, fullest opportunity was afforded to the assessee in course of the hearing. Therefore, it was held that it is not a, because the tribunal said that the show cause notice did not speak of these issues. No further show cause notice was issued, and therefore the order was, to that extent, was without jurisdiction. But the Honorable Supreme Court was pleased to hold that the assessee was put fully upon notice. The assessee, the record was available to the assessee at all times to see and participate fully in the proceedings. So kindly not have those paragraphs, but kindly take note, page 755, paragraph 12 of that reported decision.
Yes.
Paragraph 12. It may be that in a given case, and in most cases it is so done, a notice proposing the revisional exercise is given to the assessee, indicating therein broadly or even specifically the grounds on which the exercise is felt necessary. But there is nothing in the section to raise the said notice to the status of a mandatory show cause notice affecting the initiation of the exercise in the absence thereof, or to require CIT to confine himself to the terms of the notice and foreclosing consideration of any other issue or question of fact. This is not the purport of section 263. Of course, there can be no dispute that while CIT is free to exercise his discretion on consideration of all relevant facts, a full opportunity to controvert the same and to explain the circumstances surrounding such facts as may be considered relevant by the assessee must be afforded to him by CIT prior to the finalization of the decision. And then kindly take the tribunal's view is set out under paragraph 13. If I can just read between placitum B and C, he ought to have given another show cause notice to the assessee on those grounds and given him a reasonable opportunity of hearing before coming to the conclusion and passing the final revision order. In the case on hand, CIT has not done so. Those were the issues which were not in the notice. That was the tribunal's finding. Then paragraph 14. The above ground which had led the tribunal to interfere with the order of the learned CIT seems to be contrary to the settled position in law, as indicated above, and the two decisions of this court in Geeta Devi Agarwal and Electro House. The learned tribunal in its order dated 28 August 2007 had not recorded in finding that in course of the suo motu revisional proceedings, hearing of which was spread over many days and attended to by the authorized representative of the assessee, opportunity of hearing was not afforded to the assessee, and that the assessee was denied an opportunity to contest the facts on the basis of which the learned CIT had come to his conclusion, as recorded in the order dated 20th March 2006. Despite the absence of any such finding in the order of the learned tribunal, before holding the same to be legally unsustainable, the court will have to be satisfied that in the course of the revisional proceeding, the assessee actually and really did not have the opportunity to contest the facts on the basis of which the learned CIT had concluded
that the order of the assessing officer is erroneous and prejudicial to the interests of the revenue. The above is the question to which the court therefore will have to turn to. To determine the above question, we have read and considered the order of the assessing officer dated 30th March 2004, as well as the order of the learned CIT dated 20th March 2006. From the above consideration, it appears that the learned CIT in the course of the revisional proceedings had scrutinized the record of the proceedings before the assessing officer had and noted the various dates on which the opportunities to produce the books of account and other relevant documents are afforded to the assessee, which requirement was not complied with by the assessee. In these circumstances, the revisional authority took the view that the assessing officer, after being compelled to adjourn the matter from time to time, had to hurriedly complete the assessment proceedings to avoid the same from becoming time-barred. In the course of the revisional exercise, relevant facts, documents, and books of account which were overlooked in the assessment proceedings were considered. On such re-scrutiny, it was revealed that the original assessment order on several heads was erroneous and had the potential of causing loss of revenue to the state. It is on the aforesaid basis that the necessary satisfaction that the assessment order dated 30th March 2004 was erroneous and prejudicial to the interests of the revenue was recorded by the learned CIT. Now, this part is important. At each stage of the revisional proceedings, the authorized representative of the assessee had appeared and had full opportunity to contest the basis on which the revisional authority was had proceeded in the matter. If the revisional authority had come to its conclusion in the matter on the basis of the record of the assessment proceedings, which was open for scrutiny by the assessee and available to his authorized representative at all times, it is difficult to see as to how the requirement of giving a reasonable opportunity of being heard, as contemplated by Section 263 of the Act, had been breached in the present case. So it was like it was done in a manner where the full opportunity was there, the record was available for examination by the assessee, those participation. So that was the manner in which the proceedings were conducted. Now, in our case, if my lord is pleased to have volume 3, the document, the communication where they have tried to justify this particular action note, the page 387.
Yes.
But the paragraph 3 at page 387. The objections raised by you by email dated 4th November are addressed as follows. Proceedings under Section 263 of the Income Tax Act has been initiated for the erroneousness of the assessment insofar as it was prejudicial to the interests of revenue. It is quite independent of subject matter of the appeal. The PCIT is competent to make or cause to be made any inquiry as it deemed necessary before passing an order under Section 263 of the Income Tax Act 1961. It has also been stated by you that the notice discloses no statutory basis and no specific purpose. So there are two things they're referring to, no statutory basis and no specific purpose. Because the rules permit for the purposes of the Act. The statutory basis has already been mentioned in the preceding paragraph. So statutory basis is saying under Section 263. Then the important part. As for the purpose of the inspection of the seized assets, suffice it to say the department is in possession of certain information of which has to inspect the seized assets kept in the strong room. It is also stated that this exercise is relevant and useful for the purpose of the Income Tax Act 1961. So the purpose they say is information. Now that information, in the past, there have been cases where a valuation report was called for by the assessing officer. The valuation report did not come. The valuation report came on the record later. So the question, assessee said, well, this valuation report was not before the assessing officer. He cannot be faulted if he has passed the order without having the benefit of the valuation report. So then it was held that no, record means, and therefore the amendment also came in the section that record means whatever is in the record at time of examination by the Commissioner of Income Tax. Now in our case, my lord has seen that there has been an examination by the Commissioner of Income Tax. The show cause notice which has been issued, that speaks of examination by the Commissioner of Income Tax. Now, that examination, he raised an issue as to why this amount was, which should have been actually taxed in the hands of the firm, how come it was taxed in my hands, and how come that telescoping was allowed, that the assets were taken to have been acquired out of that money. So, that was a very different issue. So, when he issued that notice, he does not speak of the record, including anything else, any information or anything. Now, this entire thing has started. The 263 notice was 7th of March 2025. I filed my reply on 17th of June 2025, and this inspection notice, the first letter was 24th October 2025. Then 29th October. Of course, it's only 24th October, then 29th October, the 7th November letter for the first time spoke of the proceedings under 263, because we had the SSC had not taken objection as to on what authority is this being conducted, what is the purpose of the act. So then they come up with this. So therefore, this, and they are unwilling to tell me what this information is. Now, everything else apart, if you look at the principle laid down by the Honorable Supreme Court, it requires a complete participation by the SSC. Now, they want to, this full opportunity to contest the basis on which the revisional authority had proceeded. The record of the assessment proceedings, which was open for scrutiny by the SSC and available to his authorized representative at all times. So, that is the way the proceedings are held. Now, they want to do an inspection. I do not know why. I will be a mute spectator. Because I will not know for what purpose it is being done. What is the information they are acting on? As I submitted,
the statute is also silent on this as to whether the purpose is to be made known to the assessee or not.
But the purpose of the act has to be shown. Because
Mr. Ketan, just for the purpose of elucidation, purpose of the act must be there, but it must be there and must be communicated. There is a difference. For example, records, reasons. Reasons are there in the record. Reasons which are there in the record must be communicated to the person. There is a difference in the two.
Yes.
Now, there is a purpose for which it is being carried out. Whether that purpose is to be told to the assessee or not, or to the person from whose custody the articles have been seized or not, is the question which we are debating.
Yes, absolutely. Now, whether it is for the purpose of the act, that is also part which is the aspect which is under examination. By merely saying so, the purpose is not established. Now, they wanted to they wanted to establish the purpose by bringing a seal cover before my lord. Now, that is not a procedure which the Supreme Court has encouraged. And now, if you look at the nature of the proceeding, they are saying they're acting under this is happening pursuant to Section 263. Now, there's nothing to connect these letters as such with the show cause notice which was issued by the commissioner, or the issues which were raised by him upon examination of the record. But whether this information, there has been an examination of the record earlier. Now, there is, if my lord is pleased to have the definition of record in Section 263. But it is explanation 1. clause B.
Yes.
The record shall include and shall be deemed always to have included all records relating to any proceeding under this Act available at the time of examination by the Principal Chief Commissioner or Chief Commissioner or Principal Commissioner or Commissioner. Similarly, at the time of examination, there has been an earlier examination.
Yes.
And that notice does not speak of anything. So whether this information was it, as I submitted, the nature of the proceedings being section 263, where opportunities to be afforded, in a case which went up to the Honorable Supreme Court, cited by my learned friend, where it was not part of the notice, the kind of the disclosure, the kind of participation that Supreme Court itself has laid down. That is what was done, and that's how it received the approval, in spite of it not being a subject matter of the notice.
So he had knowledge of whatever was going on.
Yes, so therefore, the inspection, if I do not know, how do I go prepared? I will be, as I submitted, I'll be a mute spectator. Why? If it's valuation, I can then make a request that I will take my valuer. So, because valuation is a matter of opinion. They have, there's an original valuation. I mean, that was in the assessee was there, but assessee's expert was not there. It was in the bank locker. The department under section 132, there's a provision they can call for a valuer. Under section 142A, the valuer has to there's certain time frame is laid down within which he can submit his report. But it was done on the spot, and therefore the full inventory of the what was found in the locker is made, which inventory also includes the valuation. But on the earlier occasion, I had shown to my lord from the Panchanama and the annexure that is the complete inventory. Now, there's no, so therefore, it is very, very puzzling as to how do I attribute this exercise to that it is for the purpose of the Act, when I do not know how I am supposed to participate and be present, because I'm asked to be present, and I'm asked to take 2 independent witnesses. Then it will be said, well, it was done in front of you, you have accepted. Or otherwise, on the next occasion, I will have to say, now please, I want to carry out another inspection. I'll take my own expert. And my learned friend points out, since they say it is for the purpose of section 260, therefore that is the purpose of the Act now. That is they of course I will not call it the purpose, because the purpose is still not spelled out. They are taking shelter under the under section 260. Therefore, how those proceedings are to be conducted has been laid down. Thank you, I'm grateful to my learned friend that he has cited this decision. But then it has to be an open proceedings in which I know what I am supposed to do. Therefore, it's extremely puzzling to the assessee that otherwise, as my learned friend said, prejudice. What prejudice? So, if I know what case I have to meet, I will know what to do. But presently, I'm seriously prejudiced because this information is not. Somebody has made some allegation against me. I do not know if it is worthy of credence, whether it should be at all looked at. There's so many things. The original as I submitted, the original notice is completely silent on this alleged information. If he had said that this was before the assessing officer, he has not looked at it. No, that is also not. So this it's very puzzling, so to say, the manner in which the department is seeking to proceed. They have had this with them from 22, I think, from 2022. June 22. As far as the record is concerned, the call for and examine the record, the record contains the Panchnama and the valuation, the inventory and the valuation. So that is the record.
The articles won't be
in my humble submission, the articles themselves cannot be called for and examined. Because then it has to be that there's something wrong with the inventory. That inventory was conducted not by the income tax officer. That was done by the authorized officer. The valuation was got done by the authorized officer. Therefore, I think the revenue has fallen short here by not telling my lords or the SSC, of course, that what is the purpose of this, and some vague information, something which, and they want to produce seal cover. It makes me more suspicious about what it is, who has said what, why are they acting on somebody's say so. I'm with them from 2022. I don't think I can usefully take more of my lord's time.
Some questions fell from my lord. So we are the process of answering this question. 1 or 2 points more. That is only one point of view. First, I want to intend to make it very clear, Lordship, that as far as that sealed cover is concerned, I had made my submission on that day that just by reading the provisions of section 263, I am within my rights. I have restricted my arguments that I can inspect the record, and I was using the word review on that day. I stand corrected with revision. My lord, will kindly take it as it is. Now, my lord, under those circumstances, now, my lord, so my lord, what I am humbly submitting is that as far as the sealed cover is concerned, open court justice is concerned, and my lord, body order and partner is concerned, I am not treading that part as of now. What I'm saying, my lord, if I am trying to make out a case very humbly before your lordship, that if within the provisions of 263, I am within my right to inspect all the records, that is all the assessment records, which includes.
Mr. Khetan's submission is that records would include the inventory, the Panchnama, wherein the seized articles and the attributes of the seized articles have been noted. It will not mean the article itself. So it stands out of the purview of records. When you go for inspection of the records, it will mean documents, it will mean papers. The moment you go for inspection of the articles, it will mean something else than the record.
Well, my understanding of this branch of law, as far as I'm being strengthened by the decision of the Honorable Supreme Court, which I'm going to place today, and even Gujarat High Court, Honorable Division Bench of Honorable Gujarat High Court, the provisions as far as the definition, as far as the record is concerned, as in 263, and after that interpretation by the Honorable Court, it says everything. It does not carve out an exception that what is on paper and pen in black and white, that is record, and what is in the strong room is not the record. Now, my lord, that this will be my first branch of submission, which I am even making that at the cost of repetition. Now, second branch is that's supposingly, my lord, what my learned friend was trying to say. That, my lord, notice, putting them on notice, reasoning. Now, my lord, as very humbly I had submitted before my lord on that particular day, and still I am repeating it. Now, my lord, while I am
doing a revision of an order which I am within my right. I am within my right and I am entitled to inspect the entire records, which according to my submission, which is subject to my lord's adjudication, according to my submission includes that strong room, bullions, whatever it is. Now, my lord, if I am given a chance, why I am calling you there? Because it is in a safe, it's in a strong room. Now, my lord, if I open it without their presence, then it will have larger ramifications. So, my lord, I am calling them. It can be a situation where after going through and the records, whatever is there with whatever is in writing and whatever is there physically, I find everything to be okay.
But
and Miller,
once Mr. Trivedi, it has been sealed, put in a strong room, you are going to reopen it for the purpose of inspection, even if you have power. That power is not unbridled. It says that it has to be for the purposes of the act. And if it is for the purposes of the act, you are informing him because the rules ordain so. You have to give him a notice for him to be present. That is the rule.
That is the rule, Miller.
The rule says that you have to be present.
Miller. Rule says
No,
I have to put him
for
on
the
notice.
purpose of inspection of seized articles, in terms of the rule, the presence of the person from
Yes.
whose custody it has been taken
I bow down.
is required to be
I
present.
bow.
Now, if such person is called on and he is asked to be present without him being told about the purpose, the reason behind such inspection, what will his presence inure to him? How will his presence inure
Therefore,
to
I
his
am trying
benefit?
to. There are two stages. Malad will kindly take up this particular preposition in this fashion. Today, I am a revisional authority. I am well within my right while I am going through the order to inspect anything which forms part of the assessment record. Now, assessment record includes everything. It cannot be said that it is not including whatever is being kept in the strong room. This is my first branch of submission. Now, my lord, while inspecting that record, when I am well within my right to inspect everything on record in order to understand and form my own opinion as to whether the order which is under revision is erroneous or not. Now, my lord, when I inspect a particular record, then I get to understand whether there is any error or not, and then I will put him to show cause that these discrepancies I am finding when I inspected the strong room in your presence. So kindly clarify these aspects, for which he will get a chance. He is trying to stop the entire proceeding. He is trying to nip it in the bud, which is very, my lord, very surprising for me. Here, my lord, will kindly see whatever.
Mr. Trivedi, this clarification which you will ask for at a later stage, if you inform him about the purpose, he will
My lord,
be
I
prepared.
don't even know what is there. My lord will kindly appreciate once again. I know I'm trying to make a point which maybe I'm not being very articulate about it. My lord will kindly see. I am a revisioning authority until and unless, my lord, I am reading an order. The order has come to a conclusion on the basis of certain records. Now those records, certain part of those records are available to me. But just because it's a strong room where they have to be present. Records, they have a part of it, but if I open that without their presence, then there can be an allegation that there has been some tampering. Had it been a situation where it was on paper and pen, was I under an obligation to give them a notice for inspection? No. It is just because I want to inspect something which is physical in nature, like an alamat in a criminal proceeding. It is whether a person was hit by a .22 bullet, which was recovered from his body, and the alama and the gun. If I want to see, that is physical things. If I see it, I may come to a conclusion, Lordship, that nothing is wrong. Everything what is on paper and pen is matches from here, and the assessment what has been made by the assessing officer. But my lord, it is only when I inspect, then whatever questions are in my mind, while filing my reasons for that adjudication or that revision, then I put them to notice. For example, my lord reads an order, my lord. Today, my lord reads my lord's file. My lords come, my lord have formed an opinion. My lord comes and asks me 5 questions. My lord asks, okay, my lord has senior friend 5 questions. Now, my lord, that is not that my lord has prejudged it. That is because, my lords, those are certain queries in my lord's mind. The same thing is with the commissioner. There are certain queries in the commissioner's mind for which he wants to inspect that. And if he inspects that for quenching his queries, which maybe it is quenched in totality, whatever doubt he has, for which he wants to verify the assessment records, may be satisfied, then there is no question of putting any questions to them. But if there is any doubt with regard to the records being erroneous, the order being erroneous on the ground that whatever the records, assessment of the records was not proper, then he is under an incumbent duty to put them on notice, saying that, look here, these are the discrepancies I find during the inspection which I made in your presence. So kindly clarify these points. Now, my lord, that is the stage which my learned senior friend is reading from the judgment which we have cited. I am not having any issues right on that. What I was trying to submit before my lord, that this is not the stage. He is championing for the cause which will arise at a subsequent stage. If you don't allow me to inspect the records which are admittedly assessment records. Now, my lord, as far as I am not going into that aspect. That is not my case. If my learned senior friends can say that, yes, I don't have a right to assess that strong, whatever is there in the strong room, then I am out of this honorable court. But till that particular right is there, and within the definition of record, if it is included. Now, Millet will kindly, I am citing two judgments, Millet. আমাদের ওই 2000 তুমি যেটা বুঝলাম না আগে সুপ্রিম কোর্টে কেন গুজরাট তো সুপ্রিম কোর্টে অমিতাভ বচ্চন না ওই 14টা এটা আরেকটা কপি আছে নেই দাঁড়াও দাঁড়াও 14টা এটাই তো মানে অ্যাপোলজি হ্যাঁ এইটা আছে কিন্তু আমার এটা ট্যাক্স ম্যানার আছে এটা সুপ্রিম কোর্ট কেসেস না না ঠিক আছে এসসিসি অনলাইন দাও না My lord, we had my lord will kindly my lord, I rendering unqualified apology, my lord, because some portions I have inadvertently marked.
Good for me.
Sir, it is 1998, volume 1, SCC 598. আমার কাছে ওই ট্যাক্সম্যান ভার্সনটা আছে হ্যাঁ হ্যাঁ yes. Lordship will kindly allow me to place page 602, Miller, which is the mark page or the judgments, I suppose it is the 5th page of the judgment. Miller will allow me to place paragraph 8. Earlier section 263(1) did not contain any explanation that enables the commissioner to call for and examine the records of any proceeding under the act and pass such order thereon as the circumstances of the case justifies, including an order enhancing or modifying the assessment or cancelling the assessment and directing a fresh assessment. If he considers that any order passed by the assessing officer is erroneous insofar as it is prejudicial to the interest of revenue by the Taxation Laws Amendment Act 1984, in explanation was added in section 263(1) for removal of certain doubts, but it is not necessary to refer that explanation as it is related to the meaning of expression order passed by the assessing officer and therefore not relevant for the purpose of this case. By the Finance Act 1988, the said explanation was substituted with it from 1/6/1998. The reason why the legislature had to make the amendment is stated in the memorandum explaining the provisions of financial bill. We refer to only that part which is relevant for us. It is observed by the legislature that the provisions as it stood had given rise to judicial controversy in respect of the following. On interpretation of terms of record, it has been held in some cases that the word record in section 263(1) could not mean the record as it stood at the time of examination by the commissioner, but it meant the record as it stood at the time when the order was passed by the assessing officer. Such an interpretation is against the legislative intent and defeats the very objective sought to be achieved, and such provisions, since the purpose of is to revise the order on the basis of records as it's available to the commissioner at the time of examination. Now, to eliminate legislation and clarify the legislation intent in respect of the provisions of three direct tax acts, it is proposed to clarify that the legal position in this regard is the explanation to the relevant sections. The proposed amendment are intended to make it clear that records would include all records relating to any proceedings under the concerned direct tax laws available at the time of examination of the commissioner. Now, Millard, I'm now placing paragraph 14, I think. Now, Millard, will kindly come to paragraph 14. Now, the tax sector paper. Lordship will kindly take up paragraph 14. Millard.
Yes.
It is there. It therefore cannot be said, as contended by the learned counsel for the respondent, that the correct and settled legal position with respect to the meaning of the word record till 1/6/1988 was that it meant the records which was available to the income tax officer at the time of passing of the assessment order. Further, we do not think that such a narrow interpretation of the word record was justified in view of the object of the provisions and the nature and scope of the powers conferred upon the commissioner. The revisional power conferred on the commissioner under section 263 is of wide amplitude. It enables the commissioner to call for and examine the records of any proceeding under the act. It empowers the commissioner to make or cause to be made such inquiry as he deems necessary in order to find out if any order passed by the assessing officer is erroneous insofar as it is prejudicial to the interest of revenue. After examining the records and after making or causing to be made an inquiry, if he considers the order to be erroneous, then he can pass the order thereon as the circumstances of the case may justify. Obviously, as a result of inquiry, he may come in possession of new materials, and he would be entitled to take all new materials into account. If the material which was not available to the income tax officer when he made the assessment could thus be taken into consideration by the commissioner after holding an inquiry, there is no reason why the materials which had already come on record, though subsequently to the making of the assessment, cannot be taken into consideration by him. Moreover, in view of the clear words used in clause B of the explanation of section 263(1), it has been held that while calling for and examining the records of any proceedings under section 263(1), it was open to the commissioner not only to consider the records of that proceeding, but also the records relating to that proceeding available to him at the time of examination. Now, Millard, so as far as record is concerned, Millard, it is a very wide as far as this judgment is concerned. Now, Millard, I am again strengthened by another decision of Gujarat High Court. Lordship will kindly bear me. I am getting some inputs from. Millard will also take up paragraph 17. We therefore hold that it is open to the commissioner to take into consideration all records available at the time of examination by him, and thus to consider the valuation report submitted by the departmental valuation cell subsequent to the passing of assessment order, and so order passed by him was legal. The High Court was wrong in taking a contrary view. We therefore allow the appeal, set aside the judgment order passed by the High Court, and answer the questions referred to the High Court in the negative, in favor of the revenue and against the SSC. In view of the facts and circumstances of the case, there shall be no order as to cost. So, Millard, as far as that record is concerned, Millard, I am relying on this judgment. Then, Millard, this is 1998, Millard. Now, Millard, I am relying on 2001 SCC Online Gujarat 342. আমি জানি কোন প্যারাগ্রাফ 9 আছে, দেখি কোনটা তো মার্ক করা আছে। Lordship. Didi. my lord, we'll take up paragraph 8, my lord. 8, my lord, will kindly see, this is at in page 3, my lord, of the judgment, paragraph 8. Now, my lord, 8, I am not going to read it, my lord, because it is following the judgment which I had just cited before, your lordship. Now, my lord, I will intend to place, my lord, paragraph 9. May I read with your lordship's leave? Paragraph 9, which is at page 4. In our view, the aforesaid observation of the apex court clearly give the widest meaning to the word record. It is also pertinent to note that while section 263 uses the word record, the explanation goes further and states that the records includes all records relating to any proceeding under the Act. The use of plural records and relating to any proceeding under the Act do not permit any limitation being placed on the power of the Commissioner, that the power under section 263 can be exercised only on the basis of the statement which are recorded in course of search and seizure operations in respect of very assessee and not in respect of any other person. The apex court has in terms overruled the decisions of the Calcutta High Court in Ganga property so and so, on which the tribunal had relied while passing the order giving rise to these references. Now, my lord, if my lord kindly, the last paragraph again I'll notice is the same preposition. So, my lord, what I'm humbly submitting is by view of these two decisions, my lord. Here, my lord, is a case before your lordship. Now, my lord, as far as distinguishing the judgments which was cited by us, that is 2016-11 SCC 748, that my lord, Commissioner of Income Tax versus Amitabh Bachchan. My lord, we over there, my lord, we had tried to very humbly impress upon my lord paragraph 12, where we were just wanting to say that how it comes to my rescue. My rescue, my salvation only lies in this preposition, that according to my understanding of this branch of law or this particular section, there are two distinct stages. The first stage is when I get an order and I think that it needs to be revised while clearly reading that order. When I'm reading that order, certain questions crop up in my mind, which I need to verify from the records, which form part of the assessment record. Now, if it is said, the statute in its wisdom, if it says that yes, there is a bar or there is a dividing line or there is a delimitation as far as inspection of physical records are concerned, that is bullion, which are lying in the strong room, that is barred. And you can assess only by way of papers and assessment which is there, if that is the proposition of law and what is the definition of records, then, my lord, it's a different case altogether. But till the time my learned senior friend cannot impress upon my lord that this particular, there is a distinct delimiting line that you cannot touch the strong room, as because there has already been a valuation, there has already been a panchanama or whatever it is, and everything, whatever is lying in the strong room is there on paper and pen. So you need not go there. But that is not the statute. If I want to, nobody can stop me, because the statute in its wisdom says that I have a power of revision. Now, my lord, why exercising the power of revision if someone truncates my right to see the record which is available on the basis of which the assessing officer has passed the order? Then, my lord, the entire exercise I will not say will be futile, but it will be a handicap on my part, and that can go anyway. It may also go to the prejudice of my learned friend. So, my lord, I cannot be allowed to adjudicate with an handicap of not verifying them. Secondly, my lord, again at the cost of repetition, wasting my lord's 1 minute more, that, my lord, now that situation is my learned senior friend is trying to amalgamate the two positions as if one. That we have given a notice, 263 notice. After that, we want to inspect, and everything is in its finality. I will inspect, I will revise the order, and there is no reason for such apprehension. If that situation arises where I reassess the bullion after making inspection in there, and I don't give them a chance of hearing, that's a fresh cause of action. And then they will be very much within their rights, and then there will be a violation of principle of natural justice, that you have assessed something from the records in my presence. It may be you have said that whatever assessment was made regarding valuation or whatever is in the picture. If that time I do not disclose what reasons I have got to believe that the order is erroneous, then the cause of action arises. Not now. Here, you have not challenged 263. If 263 would have been challenged, Lordship, then any consequential letter, my lord, could have been challenged. But here, 263 is not being challenged. But any action taken by me in order to exercise my right of inspection under 263 cannot be curtailed by way of writ petition. And as far as the violation of audio alterum partem is concerned, my lord, if that situation so arises in future, then definitely they have a right. But not now. I only do not know what is lying there, my lord. I am going through the papers on which the articles which are lying in the strong room has been depicted on paper, which is available to my learned senior friend, which is available to me. So if we are on the same page as far as that letter, those details are concerned, then there was no question of going and inspecting the safe room. If I would, my situation is that under 263, I am wanting to have a re-inspection of that because of the assessment which has been made by the assessing officer. And therefore, I am putting them on notice for the singular purpose that there should be no allegation with regard to we tampering it. Then, my lord, after that assessment is made, my lord, I may come to a conclusion which may go in their favor, which may not go in their favor. If it doesn't go in their favor, I am obliged under the law to put it on paper and pen to maintain transparency and giving them a chance of refuting that whatever it is, that can unfold itself in many things, whatever my learned senior friend has said, calling their value as that situation will be gauged at that point of time by the department. Because I cannot foresee, neither I am omniscient, because whatever will, because trying to be judicious to the entire process, the PCIT has to ascertain that whether there is any error or not. For that purpose of ascertaining that error, he needs inspection of that record. It's as simple as that. If he does not find error, everything will be as it is. But if he finds error, he will put you to notice. So, well, that is the best case I can make out with my understanding of the statute. That's
yes. My learned friend would, the two decisions which my learned friend cited. Well, one is the case of that Manjunatheshwari. That is the example which I had given. 1998 one SCC.
Yes.
But that the evaluation had been called for by the assessing officer in course of the assessing proceedings. The report came later. So the assessee said, no, you cannot look at the report. The assessing officer had no opportunity. That is the example that I gave, and that is the decision which my learned friend has cited. So it only says that the document which came into existence later, but it was a document emanating from the department. It's an exercise started by the assessing officer, incomplete at the time of assessment, and the assessee wanted that document to be shut out from consideration. Now, the second decision of the Honorable Gujarat High Court, that is a case, the question itself, in under paragraph 1, that tells us what the controversy was, whether in law and on facts the appellate tribunal was right in coming to the conclusion that the basis of intervention by the commissioner should be part of the records in the assessment proceedings of the SSE, and the statements in the search operations regarding the son of the SSE could not be considered as forming part of assessment of the SSE, and thus the action was invalid. So it was a recorded statement in course of proceedings against a relation. So very different facts. Here, fortunately, unfortunately, the department has committed itself by in this letter that they are acting on some information. It is for the purpose of some information. They say for the purposes of the inspection of seized assets, suffice to say, department is in possession of certain information of which has to inspect the seized assets. But this is, they have committed themselves. This, therefore, what is in the mind of the commissioner is not on the basis of any assessment record. It is some information. It is not, they do not describe it as an official document. So therefore, this is no record of anyone else's proceedings, no record of my proceedings. This is not a foreign document. If it is, or if it is written, or if it's oral, I do not know. Some information, but somebody points fingers, and so therefore, in the facts of this case, I do not need to travel into the larger question. But in the facts of this case, the 263 proceedings so far conducted did not speak about anything of this kind. In October, they short of the first letter. Now, in the November letter, they say there's information. That so this information, whether it is worthy of acceptance, whether it is credible, in what context, nobody knows anything. And therefore, I feel the handicap because I will be a mute spectator to this, and it will be, I do not know what consequences. I don't see any difficulty. My learned friend repeatedly said that if the commissioner looks at the assessment record and some queries in his mind, there's no query in his mind. There's no query at all. There's something, information which is definitely not part of the assessment record. Because the very fact that they wanted to produce it in a sealed cover shows that it is not a part of the assessment record, because I would have equal access to the assessment record.
My lord, we are not pressing on the sealed cover. My lord, the first day, my lord, we have not even handed over the sealed cover to them. How, my lord, at the first instant of the hearing, the matter went. What I am saying, my lord, we had brought a sealed cover because in the initial day, I was not in court, my lord, and I was not privy to the proceeding. Now, my lord, the judgment was so cited. In order to avoid all controversies, we have taken the sealed cover back. Now, my lord is not taking cognizance of that sealed cover. So that particular apprehension that because
Mr. Trivedi, it's clear from the records that you are acting on the basis of some information. That is the letter. The letter which has been impugned says that we have information. Now, it is that information which the SSE wanted to know. That has not been made over to the SSE. That is the point.
My lord will kindly appreciate that as far as information is concerned, information a particular legal action may be triggered off by any information.
Very well. If that information is such that his articles seized from his possession are being inspected, why should he not be put across that information?
Well, my lord will kindly appreciate this particular purpose.
I mean,
because that will complicate, what happens. That complicates issues. My lord will kindly take this preposition. Supposingly, I am a police officer. Or I am a person passerby. I go and complain to a person that your house has been looted by someone and you have been removed from possession. Now, my lord, that particular person goes and files one civil suit under Section 6 of Specific Relief Act for being dispossessed. he exercises his civil right. And he files a complaint of house lurking, house trespass, and everything is a Now, will a person who is the accused say that you please tell me what was the information given to you? Subject to, pursuant to any information under the sun. If I exercise my right within the law, and by exercising my right, if I go and see it from my naked eyes that that has been done, information is of no consequence. Pratyaksham kim pramanam, the little Sanskrit which I know. Whatever I see from my eyes as an adjudicating authority, I have to decide on that. Any information coming, and that information, that means they are thinking that I have been prejudiced by that information. That is they are proposing, they are behaving as if in an omniscient manner. That cannot be. Information, my lord, information, it can be through any information, it may not be through any information. And even if there is an information where under the law I am bound, for example, I gave example to my lord, my property has been, I have been dispossessed. I was working in my office. Somebody comes and tells me. I go to the property, I find, yes, I have been dispossessed. I lost 2 complaints. Will the court ask me that who was the informant? I am the de facto complainant. I am the plaintiff. And I am within my rights. So I am the revisioning authority. I am within my rights. It may be on some information, it may be suo motu. But while coming to adjudicating and coming to a finding, at that point of time, audi alteram partem, all the peripheries of law and all the paraphernalia which have been prescribed in law should be given to them. But not before that. Now, who gave me an information? Why should I act on that information? That information was right or correct or not, that I have already assessed. Therefore, I am going into that revision. Now, Miller, that is stretching my action in order to bring an angle of prejudice which may help their purpose of stalling the entire process.
What do I do? Should I?
We are not relying on any sealed cover. Ma'am, I have, because Miller, that is
Very
going
well.
to.
I am hearing for all practical purposes has been concluded. I'll keep it one day after the vacation immediately. If I have some queries, I don't know.
My lord, one day after the vacation, my lord, second, I'll be in personal difficulty.
No. Any day after the vacation. One day means any one day after the reopening. May not be on 2nd, may not be on 5th. You
One
tell
day
me a
after,
day.
my lord, I took it literally. One is one. Not that one which my lord was saying. My lord was saying one particular day after vacation. I took it as if it
Any
will be
one
on the
day.
second. Yes, my lord. I.
You tell me a date, I'll keep it on that day.
No, any date, no, since my lord.
After 8. After 8.
After 8. Any date.
We can have it on 9th.
Not sure. Huh? My lord, my lord will keep it. My lord, my department is in a hurry, but then, my lord, according to my lord's diary, my lord will fix up a day.
9th is good Friday.
So whenever my lord's diary permits,
before-
my lord, if it is
before the
slightly
law.
earlier, then we will be benefited. Otherwise, my lord's diary permits whatever falls from my lord, I will never.
He said after 8th. So you can suggest, you can agree to
13.
No,
No, 11.
Who is the
11th.
Sunday.
Sunday. It's very good. You come on Sunday.
My lord, you not take. My lord, 9th, if it can. 11th,
Okay, tell me a date then. You tell
my
me.
lord,
a date.
any time, if he is in difficulty on the 9th, my lord, 8th or 7th or.
He was in difficulty. He said after 8th.
15th.
8 तारीख को बीच में कोलकाता ही नहीं.
कोलकाता की हुई ना तो की
Well, 15th, because there'll be no clash with the division bench also.
My
Because
lord, the
Mondays,
problem is that I am in slight pressure from the department, my lord, because they are because this the entire process.
Then 9th.
My lord,
9th. and
9th. I'm grateful.
but in case there's a clash, 2 p.m. it might be.
Yes, my lord, that I'm always ready to accept.
Very
I never.
Heard Mr. Khetan, learned advocate, learned senior advocate appearing for the petitioner, and Mr.
Today is his birthday, my lord. Madam, we are classmates. Your lordship may not know. We are classmates.
We are classmates, and we have passed law together.
Passed over matter.
It's for judgment.
Oh, these were that.
Petitioner, you're there, Mr. Raju? Item 4 and 5, you're there.
Yes,
I'm sorry, I have dismissed it for want of territorial jurisdiction. You'll get the order on the circular. Both the matters, different orders. One, Mr. Khetan's words, another, his words from your mouth.
We are grateful.
Great. দুটোই
দাদা তুমি তো পাস হও Well, I am for the petition. I am late by Mr. Mujumdar.
Mr. Mojumdar, don't take long because the original
only
side
very short matter. But
It's a short matter, but he is challenging the assessment order, which is an appealable order.
is the applicable always. The assessment order is always applicable order. With certain dispute, with regard to the.
Can't it be had tomorrow? Tomorrow morning.
Tomorrow difficulty, Mr. Mujumdar is out of station. So I.
Short. Only thing is original side.
I understand.
It's already 3.
I don't want
Because last 2 days also I couldn't take original side for more than.
Come back on 5th.
Yes, we can.
Fifth.
Fifth.
Come back on.
Yes.
After tomorrow, your lordship will be sitting.
Yes, I'll be sitting, but I don't know how long will these matters take and.
Whatever. Man, it is subject to business of the honor.
5th is all right.
As all.
I'll be sitting every day. I can't have the liberty as you all. Heard Mr. Mojumdar, learned senior advocate, appearing for the petitioner. Tomorrow.
No. With regard to item number 22 of the in your lordship says today.
Yes.
A council form online will mention before your lordship.
May it please your lordships. May I, my lords, may I make a small mention? On the last occasion when this matter was there, my learned friend had said that he will take instructions on because the petition really challenges the non-grant of refund. He was going to take instructions. Now, my lords, what has happened is that we have received an order where he has adjusted the refund for assessment year 2004-5 against an alleged demand for assessment year 21-22. And now for 21-22, they have passed an order giving effect to a tribunal's order where relief was completely given to me. And now they have determined a refund for 21-22. Right. My lords, my learned friend will tender a copy of that order which has been passed by the officer giving effect to the tribunal's order for assessment year 21-22. A refund of 123 crore has been determined. Now this determination, Milords, was done in November 25. Today we are in the last week of December. So far we have not received the refund. This is exactly the thing which had happened even earlier, that they determined a refund, but they did
You are
not pay
appearing.
it to us for 1 year.
You are appearing in this matter. Item
Yes.
22. If refund has already been determined, why are they not getting it?
This matter, was no notice was given of the mentioning. Only I got an SMS that you were mentioning today.
Please take
You are
it.
not
I have
I'm not
given a WhatsApp message to him, my lord. Please be there.
I am not ready with my brief now. The instructions have come from them, and they have only asked for a few days time for the payment to be made.
Can we have it tomorrow then?
That yes, kindly keep the matter tomorrow.
Stop, my lord.
Not today.
I
Tomorrow
shall-
it will be taken up tomorrow.
I
Certainly,
have got
Milord.
the instructions. I
If both of you are here, please mention. I'll immediately
Yes,
take
my
it.
lord. Yes.
Because it's a
Grateful.
small matter otherwise. If you have already agreed
Yes,
to
yes, my lord.
refund, it will be
You know,
refunded.
the refund has been determined. It has to be
Yes,
absolute.
yes. Tomorrow.
Deeply
Grateful.
observed. Same time.
Same time, yes.
Deeply observed.
My lord, before your lordship takes the original side,
I've already
Milord,
started taking originals.
item 58 and 59 will it
I was waiting for you all. Nobody turned up. I took original side later.
Milord, we were there.
There was a matter fixed at 3 for judgment. We delivered judgment. Then there
we
was
were there,
submissions being made for the original side matters.
Milord, your lordship's pleasure to keep it at 4. Milord, we were
How
there.
can I stop in the original side? What is the urgency? I don't understand. What is the earth-shaking
Milord,
urgency?
without giving an opportunity of hearing that I am entitled to under section 4C of the Land Reforms Act, that the authorities have proceeded to demolish my factory premises, Milord. Milord, that was the urgency, Milord.
Where is your other side?
Milord, we have served notice, Milord.
Notice serving will not do. If you want it without call Korun. And if you bring your other side, let us see if the appellate side people are there.
At 4 I shall.
I don't say 4. Let us. I'm not promising 4.
Milord, we'll try your luck, Milord.
You try your luck, yes.
For the
Yes.
respondent, my lord.
This matter stands released. This matter stands released from this list on my personal ground. And let this matter be placed before the Honorable Acting Chief Justice for appropriate orders.
My lord, I am appearing for the petitioner.
Yes, I have released it.
Obliged, Your Lordship.
1 to 5, same order. Call which?
I
am releasing.
Item number 2. Sign this matter.
Yes, yes. Give your name, give your slips, it will be recorded. এটা ধরুন।
Item number 1. Okay.
Item number 3.
3.
Same order. Released. Oi, 2, 3, 4, 5. 5 of the same order.
Item number 4.
Same order. Released.
Item number 5.
Same order. Released.
Item number 6.
And for the petitioner, Your Lordship, this is that matter where the entire finding was was copied from the show cause notice. Your Lordship, hearing had concluded.
Yes, I am formally concluding hearing. I am reserving judgment.
Your Lordship, I had handed over a list of event to show that my knowledge was subsequent. And Your Lordship, I had also handed over a written short note of submission.
देखिए আছে किना একবার দেখে নিন। Yes, there. Very well. लिखे in the hearing.
That notes if it may be recorded in the order.
It's there.
There, Your Lordship. Grateful, Your Lordship.
ও লিখে রেকর্ড করে নিন
Your Lordship,
written
for
notes
our
of
benefit.
arguments written notes of arguments filed ওপরে hearing is concluded এর আগে written notes of arguments
Grateful, Your Lordship.
written notes তো পাইনি কিছু she handed up on the last occasion
Last occasion.
handed up to court
Last occasion. এইটা দিয়েছিল।
you want time
Yes.
Your Lordship, I don't remember. I have handed it today. But I had
written
handed
note
it
you are not
over
required to
the
read like
Your
a
Lordship.
affidavit in opposition
Your
you can
Lordship.
exchange written notes you want time to file written note I can give you you want time to file written notes
Then my lord, kindly fix a date after vacation we'll file the report.
Your Lordship.
তাহলে ওটা কাটুন
Then Your Lordship, I take back. It may not be
written
recorded, Your
notes
Lordship.
written note of arguments filed on behalf of the petitioner is taken on record yes plus CV হচ্ছে না তো না 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 written note আবার টাইম হলো তো কমপ্লিটই হচ্ছে না তো
My learned senior is saying that I should not have insisted on recording it only.
no not not a problem হ্যাঁ কল করুন
Item number 7.
I'll just update my lord this bench that the matter still pending in Supreme Court. Returnable date is now on 6th of January.
so I'm fixing it after 6
Yes, sir.
none appears for the respondents list
Item number 9. Your Lordship, senior advocate. Your Lordship,
I have already filed the affidavit in opposition.
but I have not received it, sir. I have not received it. No. Okay.
no it has not been filed time was taken to file that is the recording 21st of November 2025
Yes.
But on instruction of my junior milord, they have.
no there is no recording to that effect 21st November 2025 order
Yes,
says you
order,
took time.
yes, Lord, order is passed. Everything in opposition within 2 weeks and reply within
where
1 week.
I don't have it in my records
But
where is it
on instruction of my junior, we affirm
I
that.
don't have it in my record where is that
There, huh? We will, let the matter be appear.
Mr. Sharma you have filed an affidavit in opposition
Earlier I was engaged by the department.
So,
In the first matter, which is the leading matter, no reply has been filed.
no there is nothing in on
Yes.
record also
Lord, they affirm the affidavit, Lord. But
you
he
may
will
have
start-
affirmed but till such time it comes to court I cannot
Yes,
record
yes,
that
yes, Lord. He will start the copy of the opposition, Lord. And Lord, let the matter be appear after.
Your Lordship,
Oh, yes, Lord, yeah. This is an agreement opposition. At a copy. Lord, I am handing over the copy of it. So,
Affidavit in opposition. দেখা বড় হবে এটাতে same order.
Pilot, in this matter, I'm led by Mr. Jaswal. They are new in the panel. He may turning.
Very same order. All these matters, I am directing them to appear as adjourned motions because they will unnecessarily occupy the motion list. Adjourned motion করুন। অসুবিধা আছে? Adjourned motion. As adjourned motion, Didi. List these matters.
Minus 11 also.
11 same order.
Item number 12.
Affidavit file.
Yes, madam, 12.
Same order. Copy served.
Yes. Copy served, madam. Item number 13.
13, my lord, I am for the respondent.
Petitioner.
Mr. Dugar was
allowed to appear virtually, my lord. I am appearing virtually, my lord. Your lordship
Mr.
is,
Dugar.
am I audible, my lord? Am I
Yes,
audible?
yes, you are.
My lord, this
Yes.
is the case I have come against the inaction on the part of the authority, my lord, in refunding a sum of rupees 44,11,000 arising out of the state's order, my lord. Tribunal's order, my lord. No, my lord, on the last occasion, my learned,
Or we have filed the appeal. Appeal is pending and is appearing before the
my lord,
list of the honorable division bench as item number 127 of today's list. But the appeal will be taken up for hearing any day after vacation because it's in the list and the stay
Mr.
application.
Dugar, the appeal is in the list.
it is in the list, my lord. On the last occasion, my lord, they said that they will take the, my lord,
Last occasion, last occasion, there was a doubt as regards filing and all.
We have filed,
Yes.
we have filed upon it.
Stay petition they filed, my lord.
So they have filed a stay also. Let us wait for some time. There is no tearing hurry immediately.
Then, my lord, in that case, my lord, kindly allow them 1 month's time or, my lord, 2 months' time, my lord, so that the matter can be dissolved, my lord. Or, my lord, your lordship will pass the necessary order, my lord,
Very well.
after the expiry of 2 months.
Mr. Dale, an advocate appearing for the respondent, submits that a statutory appeal has been filed against the order dated February 13, 2025 passed by CESTAT, CESTAT. CESTAT and that such appeal is appearing in the list of the Honorable Division Bench. Full stop. Since the admission of the appeal, it has also been, stay application has also been.
Stay has also been filed.
It is further submitted that an application for stay of operation of the order impugned has also been filed in connection with the said appeal. Full stop. Since now, full stop. In view of the aforesaid submissions, comma, it is desirable that this court should await the outcome of the appeal, in as much as the writ petition seeks implementation of the order passed by the SESTAT. It is that only, implementation of the order.
Yes, yes.
Passed by the SESTAT. Full stop. Accordingly, comma, list this matter on January 28, 2027. 28
In July,
January.
yes, my lord. In July, we filed this writ petition, my lord. From July, it is pending, my lord. Kindly consider this.
But if it is stayed ultimately by division bench, what will happen?
They have not, my lord. Ultimately, what happened? The amount of threshold limit, my lord, below which, my lord, the department cannot file the appeal, my lord. That in this case, the threshold below, it is much below the threshold
Let us
limit.
see if the appeal has been filed, it is pending. I don't think I should, as a single judge, immediately
Yes,
trample down
yes,
whatever
yes.
is there before the division bench and pass orders.
I'm grateful.
Grateful to your lordship.
Thank you.
But I'm waiting for this one. But this is that matter, my lord. My lord, I was arguing that, my lord, that there was search and seizure was my lord, in the case of Kasera group, my lord, certain rukkas were found, my lord. In the rukka, my lord, was seen that that my lord, certain loans were taken.
Yes.
Yes, and my lord, I was placing the relevant. Lord, for your lordship's kind consideration, I prepare a short note, my lord. That will help your lordship, because our point was what my submission, my lord, 3-4 pages note, my lord. If your lordship will kindly consider this, my lord.
That will be very helpful.
Yes, yes. I'm handing over to my friend also, my lord. No. Yes. Judgment which I have the site, not the presence are there, my lord. Yes. Lordship, kindly have a look at.
Also give me liberty to submit my note also. Just after vacation, I will submit.
Yes. Here the petitioner has challenged the 148A notices, certain such. The petitioner only ground of challenge of section 142 proceedings could not have been initiated against him in accordance with him. Purportedly, no information against was available to the assessing officer. The instant case, the basis was search was Kasera Group 2018. During the search, several rukkas have been found and found and indicated that the petitioners has taken a cash loan of 55.10 crore through brokers controlled by Kaseras. So, my lord, the statement of Uma Shankar Kasera and Praveer Kumar Kasera have been produced in pages number 28 to 42. If your lordship will kindly have a look at pages number 28 to 42, that is there, my lord. And 43 to 84, respectively, in the petition, wherein the modus operandi of accommodation entries through rukkas have been introduced. So, my lord, that modus operandi I had given site on the earliest details were. Some relevant information is found in page number 63, question number 28, that it shows the H.M. Singhania as someone who
You are reading which page, Mr. Duduria?
But I'm first page. I'm this
no.
notes.
No, I was.
Very well. But that, first of all, my lord, from the notes, it will be easier for your lordship to. Yes. So in this case, the petitioner has challenged. My lord, yes. The challenge 148A notices there is such order under section. Now, if your lordship will kindly say page number 5, point number 5. Some relevant information is found at page number 63, question number 28. Lordship will kindly see page number 63. Question number 28. Please go through the seized records, loose sheets, such and such. These pages are rukkas, transactions, the detailed transaction enumerated in these pages are summarized in a tabular form. That rukkas transaction note which I have shown it to your lordship, my lord, page number 251, 52. Then, my lord, page number. On page number 61, Pavin Kumar Kasera admits that he had orchestrated the transactions. The page and page number 68, question
Yes,
number.
yes, I have seen it.
Yes. So, my lord, what my humble submission before your lordship, I have given it to your lordship, my lord. The first of all, my lord, I showed it to the my lord, your lordship 148A1 notice, that is page number 28, 23, 24, my lord, the basis of info. But hurriedly, I'll show page number 23 first, page number 24. But these are the search and seizure on the basis of certain information are found. Therefore, 140 proceedings has been initiated. Page number 24. Page number 24, search and seizure along with operation analysis of the documents found in the Mr. Mayank Agarwal, Managing Director of the Maya Fashions Limited and Srilaja Housing Private Limited. They has taken a cash loan of 55 crores, 10 lakhs through the financial broker. 179 liability of directors private limited company. But this is not I've shown it to you. I don't want to repeat your lordship. Then thereafter,
It's there in your note. It's there.
Yes, everything is there in the note. Not only the judgments which I wanted to cite. Yes. If your lordship will kindly see, my lord, in my note, I have marked the judgments. My lord, first of all, my lord, only thing, my lord, there are two judgments, are very big judgment, my lord. I need to share it online, my lord. My lord, one is, my lord, Vodafone judgment, my lord.
Vodafone Holdings.
Yes. My lord, paragraph number, I'm relying on paragraph number 74 and other paragraphs.
Group companies.
Yes. Then on the proposition, my lord, circumstances, evidence has to be taken into record, my lord. Not only what their submission is, my lord, that nowhere Mr. Mayank Agarwal's name is there, but it is an admitted fact that actually, my lord, who is gaining, being a director of managing director of a managing director, entire amount is coming to him. For that proposition, my lord, I am citing the Vodafone judgment. And my lord, another judgment which I was citing, Radhakishan Industries, my lord, that is also, my lord, in my note, my lord, page, serial number 14.
14, yes.
14, yes. Here also, my lord, this is also a big judgment, my lord. This is a proposition I've stated, my lord. It is well resorted, order does not suffer from any lack of jurisdiction or violation of natural justice. The principle laid down specifically, which Article 226 may be invoked in the instant case, does not satisfy the any of the four ingredients. My lord, may I just, yes. By the contact. Radhakishan. Vodafone. Yes. Vodafone, paragraph number 74. Okay. अच्छा जी
Radhakrishan, which paragraph?
Paragraph 27, bro. Paragraph 27, Radhakrishan.
Twenty-seven,
my lord, yes.
Alternative remedy.
Yes.
Very
now, my lord, next judgment, my lord, I am placing Anshul Jain, your lordship.
Anshul Jain, I am aware.
Supreme Court, and then also both the judgment, your lordship knows. Yes.
Deep.
Then, my lord, I am placing judgment of Rajesh Javeri.
Rajesh Javeri also.
Here, your lordship knows that I have taken in that. Then also, my lord, in my lord, paragraph 4 of selected Dulachan Cole reported in such and such hold at the stage of issuance of notice of reassessment. The only question is whether the AO could have reason to presume belief for escapement. That this judgment, Your Lordship, I am just placing, Your Lordship. This is, my Lord. Just a minute. Only this judgment, Your Lordship. Yes. My Lord, if Your Lordship will kindly have this judgment.
Paragraph 4.
Yes, my Lord.
Seen
Paragraph
it.
4. Yes.
Last
Yes,
part.
yes. And my Lord, Vodafone, my Lord, I am showing paragraph number 74. Mail Quran. On the proposition of principle of surrounding circumstances, paragraph 74 and more.
Yes.
And Your Lordship knows the
এটা
judgment
দিয়ে
of
দিন।
Your Lordship knows the judgment of Durga Prasad More and
Yes.
Sumati Dayal. Durga Prasad More and then Sumati Dayal, my Lord. Yeah. In my note, I have stated 11 paragraph 30. Then thereafter, my Lord, thereafter, Raymond's Woolen Mill, my Lord, another judgment I am citing. Raymond's Woolen Mill. Yes. Raymond's Woolen Mill, my Lord, paragraph number 3. In this case, we do not have any, we do not have to give a final decision as to whether there is any suppression of material facts of the SSC or not. We have only to see whether there was a prima facie some material on the basis of which the department could reopen the case. The sufficiency of the and the correctness of the materials is not the thing to be considered at this stage. We are of the view that the court cannot strike down the reopening of the case on the facts of the case. It will be open to the SSC to prove that the assumption of facts made in the notice are erroneous. The SSC may also prove that no new facts came into the knowledge of the income tax officer after completion of the assessment proceedings. We are not expressing our opinion on the merits of the case. The question fact that left open for the investigated and decided by the assessing officer, the applicant will be entitled to take all the points before the assessing officer. This is the judgment. But thereafter, my Lord, I will be citing only one. I am citing two judgments. Yes, my Lord. Judgment part is over, my Lord. But another thing, my Lord, in my my Lord, written submission, Lordship will kindly have a look at number 20, serial number 20, point number 20. Yes. But they are saying for the same offense, why you are giving punishment twice? Because the penalty proceedings has been initiated. But penalty proceedings has been initiated for a violation of section 269 SS. That is a separate proceeding. That's why it has got nothing to do with my Lord. That I have specifically stated in paragraph number 20. Lordship will kindly have a look at that. Yes, my Lord. These are my respectful submission. I have not taken into your Lordship. So I your Lordship will not take more
Yes,
than
Mr. Agarwal.
Yes. I have also handed over to him the copy.
My lord, may I also submit a note just after reopening?
Submit, but don't make it very long.
I will make a short note.
Yes, three, 4 pages, because if it goes beyond 3, 4 page, I will not be in a position to.
I
It
will-
becomes a petition, then it's difficult.
I will confine.
It should
Vinod,
be,
to-
it should be as concise as this.
I am used to that writing short notes. I no difficulty, my lord. Just a few points I would like to make. My lord, the vital issue that I have raised, none of the issue has been answered by my learned friend. For example, my lord, nowhere my name is appearing, neither in the statements of the two persons which have been given to me, nor in the rukas which are reproduced in the purported information and the order passed. Nowhere my name, I am a different person than company. The well-known case of Solomon and Solomon, I would refer to only one High Court decision on that point. Lord, in a civil matter, para 8, my lord, the issue has been dealt with by Honorable Kerala High Court, wherein at para 8 they have also referred to Karnataka High Court, relying on Solomon and Solomon decision. This is the textbook decision we have all learned. That company is a separate entity and proceedings have to be initiated separately for the directors. Then, my lord, in the table at page 92, which the department has provided to us, there they have grouped all the borrowers under me, different borrowers, and admittedly I am not the borrower. The strange fact is that I am not the borrower. Other than me, other borrowers are grouped under me. That is the strange fact. How 179 can be invoked, my lord, that my learned friend has not dealt with. My lord, if we look at section 179, subsection 1, it says that unless the money, tax, cannot be recovered from the company concerned, then only director will be liable to it. And latter part of subsection 1 says that I can prove during the proceedings under 179 that the non-recovery is not attributable to me. That I can prove. Only I can prove if 179 proceedings have come into play. Otherwise, I can, because no liability has been created at this stage against the company. And the remarkable feature that the information provides that I may be the potential lender, probable unique names are there, and potential and probable word has been used at page 92 of my petition, wherein that is part of the information that they have provided to me, and the judgment that I have relied upon squarely applies Girdhar Gopal Dalmia, which my landlord friend has not even hinted that it does not apply. Lack of jurisdiction, why I have availed the writ remedy? Because AO did not have the jurisdiction to invoke section 147. First proviso to section 147. Section 147(1) says, if income chargeable to tax in the case of the SSE, that is to be underlined, in the case of the SSE, then AO can reassess such income. So all the judgments which my learned friend has cited falls flat, because department case, he has not brought on record any material that my income has escaped assessment. Number one. Number two, the cash loan that the case of cash loan that they are making, that I have taken cash loan or my associates have taken cash loan, that does not partake the character of income. For that, only a remedy with the department is to levy penalty under section 271 capital D, which they have levied already, which is part of my petition. First proviso to section 148 says, no notice can be issued unless there is information with the AO which suggests income chargeable to tax as escaped assessment in the case of the SSE. So this proviso is also not being satisfied in my case. Now, Excel commodity live nexus story that also goes unrebutted, and latest I have filed Karnataka High Court decision, my lord. And then I will file a court note just after vacation, my lord. Not expecting.
My lord, only one, my lord. Page number 2 of my note, my lord. Point number 30. What my learned friend said, my lord. I have specifically indicated those pages. My lord, kindly have a look at page number point number 13. And the page number 176 top indicates how the department decided to issue the section 148 notice. Page number 176 bottom and page number 177 shows that there has been no violation of natural justice. Page number 179 shows that there was a direct link between the material relied upon and the petitioner. Page number 180 bottom indicates that there was a tangible information against the petitioner. That, my lord, I'll place if your lordship. If your lordship wants, my lord, I'll place those pages, my lord. Your lordship will kindly come to page number 176 first, my lord.
176.
Yes.
Yes.
Lord, the information received to the high risk such and such channel as flagged intelligence under our risk management. Strangely, the formulation of CBDT, the details of the cash transaction along with the PAN and the name of the source of the party, Umasankar Kasera, and the transaction values and the involvement of the SSE in the beneficiary were disclosed. The SSE was asked to furnish the corroborative evidences, books of accounts, and the explanation. This satisfaction both the statutory and procedural requirements under section 148A, read with 112. Rule 12AB of the income tax rules. Then thereafter, my lord.
May I give rebuttals simultaneously, because again I will have to
Lord, again, Lord, one.
एक एक करके हम रिपीट भी करते चलते हैं तो इजी रहेगा ना my lord. Time will not be wasted. One line only I will say.
Yes,
my lord, I cannot prove the negative. When my case is that I have not taken loan, where is the question of producing books and say that I have not taken loans?
Yes. Lord, the next is, my lord, page 176 bottom, my lord. Says, my lord, section 148 capital A of the Income Tax Act is intended to strike the balance between the rights of the SSE and the legitimate interest of the department in curbing the evasion. The provisions mandate that the SSE be provided with an opportunity of being heard before the notice on section 140 is issued. However, the requirement of disclosures must be read in the light of the doctrine of probabilities and the purposes of the provisions. Now, my lord, thereafter, my lord, will skip over the SSE was provided with the core material forming the basis of information determined by report. Then, my lord, page number next, my lord, the granted the reasonable opportunity to respond, my lord, when thereafter allowed to submit the books of accounts supporting documents. Therefore, there was no violation of principle of natural justice that I have stated. And
I am not contending that you have violated.
Now, next, my lord, page number 179, middle portion. Page number 179. Which says, my lord, the identity of alleged direct link to SSE has claimed these documents are hazy, contain the rebuttal of the SSE submission or objection raised by the SSE regarding the identity existed in section 148 of the Income Tax Act. This is not the SSE has claimed that the C6 document is a hazy content. That document has to accompany which is the managing director. There is a respectfully submitted that these are the line of objections considered as both the system of reviews and the standard. The case was flagged, but there was a high risk management based on the specific inputs that the search and seizure action conducted on 30/11/2018 involving the multiple finance brokers. The name of the SSE appears explicitly in the determination note uploaded on the instant portal, identifying that SSE has the beneficiary of unaccounted cash flow transaction amounting to 2.5 crore. This is not a case of a generic or line matching. The inside portal data is derived from the systematic forensic analysis of these materials corroborated with the public domain data, PAN, financial affairs, and market intelligence. Well, this is the paragraph. Yes,
my lord, in the reply I had submitted, various pages are hazy and not readable. And if you look at the pages also, my lord, page 201, 203, And one cannot make out a head or tail out of these documents, whose names are there, nothing can be deciphered. So when I have objected that the papers are not hazy, then they should have come out with some material which proves that the legible material where my name is appearing. At least at that stage they should have come out. Still in the rebuttal in the order, they are not coming out with the fact that my name is somewhere in those hazy bunch of papers, my name is somewhere appearing. At least that page number they should have referred to, that is also missing here.
Next is page number 180, my lord. Page number 180, my lord, bottom. On the nature of modus operandi, my lord, the SSC claimed that the case is based on a general modus operandi lacks substance. It is submitted that each flagged case is investigated separately. Whole modus operandi forms the investigation back.
Yes,
Lordship has seen. Then, my lord, page 182 top. Page number 182 top. Lordship will kindly have a look at that. But this indicates the specific reasons for invoking 148A. Page 182 top.
Yes.
Then page 184 middle, which shows there was enough data to form a prima facie case. Page 184 middle. Page 184 middle. Yeah.
Got it.
Yes. Then page 185 bottom. The SSC is not a mere director in the name. He is a managing
It's
director.
there in the note, Mr.
Yes, my lord.
Right.
No, he says that he was not connected. That's the
Again, you are saying you are proving my case. I am
Yes.
saying if
This is
I
not
have
required.
taken
Ultimately,
separate
who is
proceedings
the
for
beneficial? My lord, he is taking loan from CMI. Actually, he is earning the
My
money.
lord, when
Loan-
company has taken the loan, admittedly, what was the difficulty in proceeding against the company? Why penalizing me separately? A company is having several directors, several shareholders. So separately penalizing me, my lord, this is something new I am seeing. Income Tax Act, if you look at the provision, SSC persons have been defined. Separate proceedings are initiated against each person, company or director or individual or HUF. These are the persons as per the Income Tax Act. You cannot club everybody under me.
Very well. When can you file it?
My lord, on reopening,
Give me a date.
File code. In the
Fifth.
court,
Yes, yes. I'll keep it on 5th. And what about the other two matters?
Other
These two matters, my lord, same facts are in other two matters, my lord, penalty proceedings have not been initiated.
in
one matter, penalty proceeding initiated, another matter not initiated. Otherwise, my fact.
They have not replied.
Yeah, yes. The only difference is, my lord, in those two matters, my lord, they have not replied to the show cause notice. Here they have replied.
Because my averment is that the
Yes,
person
otherwise
was
not able
sick at that relevant time. It was sent in the mail, which was not accessed. Therefore, reply was not. But the facts are same, my lord. And in one
of the cases, penalty proceeding has been initiated.
लिखे नहीं item 14 का लिखो ना
penalty.
Yes.
So 646, I mean 15 and 16, I'm just keeping hard.
If they file different note, but we'll also file that. But a separate order may be passed.
I have passed separate orders. only.
Grateful.
That is heard. The other
Yes.
two are only heard without
yes.
notes. The other one is with notes.
I'm so grateful, bro.
Grateful.
Grateful for patient hearing.
Item number 17.
Yes, Mr. N.
My
Before the vacation, would you like to enter into this?
Lord, if your lordship is kind enough to take it after vacation.
Yes, because it is a heavy matter. Every
my lord,
the
also
entire board will be
my
stopped.
senior is also stuck in court 3. There's a contempt matter. I was also there.
That is only one humble request. Only one humble request. If your lordship fixes a date after the
Tell me, that is what I'm telling.
first week of any,
First week means 5th, starting from 5th.
my lord. Can
When?
it
Give me a date.
Wednesday or Friday? That
Fridays
Zoning
will
should-
be specially assigned matters. Friday
Wednesday,
won't be.
Wednesday
we can have.
should be 7th.
My lord,
Yes.
7th, my lord, 7th, some difficulty, my lord. 8th, if my lord, please.
As prayed for by the parties.
Okay.
Item number 18.
Lord, kindly have this after reopening, my lord. My lord, in the week of 12th of January, anytime in the week of 12th, because one lead matter is there on the week precedings, we will, there'll be some assistance.
As prayed for by the learned advocate appearing for the petitioner.
No.
Thank you.
Yes. Yes. Today you will conclude.
My lord, yes, your lordship. In fact, your lordship, I more or less concluded, my lord.
Yes.
I can, my lord, only, but last night I just want to, again, my lord, place the decision of the Honorable Division Bench, my lord, in the case of Excel Commodities, but I placed it earlier, your lordship.
Yes, that please. Excel commodities, yes.
Just paragraph 4, my lord, just to show.
Yes, paragraph 4 is noted.
Yes,
That is what was placed.
Yes, your lordship, that, my lord, 4, my lord, because it clearly shows that, my lord, it might may just take it, might once again, if it may be convenient. It says further, we take note of the circular issued by the Central Board of Direct Taxes dated August 22, 2022, giving instructions to the department with regarding to uploading of data on functionability portal of the Income Tax Department. The circular emphasizes the earlier circular dated August 1, 2022 in paragraph 3, wherein it has been stated, before initiating proceedings under section 148/147 of the Act, any information available on the database or portal of the Income Tax Department shall be verified before drawing any adverse inference against the taxpayers. It is not out of place here. It is not out of place to mention here that the information made available, data uploaded by the reporting of entities, may not be fully accurate due to inter alia error of human nature, technical nature, etc. Therefore, due verification may be carried out and opportunity of being heard be given to the taxpayer before initiating proceedings. The supervisory authorities are hereby advised to keep an effective supervision to ensure that all extant instructions, guidelines, circulars, SOPs are followed by the assessing officers in the case. From the above, it is clear that it has come to the notice of the Central Board of Direct Taxes that in several cases, information made available, data uploaded by the reporting authorities are not fully accurate due to error of human nature, technical nature, etc. Therefore, the department was advised to effect due verification and opportunity of being heard be given to the taxpayer before initiating proceedings under section 148/147 of the Act. Thus, in the preceding paragraph, we pointed out that the factual position in the case on hand, as it appears, that proper verification was not done on the information which was available with the assessing officer at the time of issuance of notice under section 148 AB of the Act, which has led to the erroneous order dated April 7, 2022 being passed. And this shows that it is not that merely that data has been uploaded to the department is to issue a 148 notice. The department itself acknowledges that it can be subjected to errors, and often I have also seen notices being uploaded. My data from the investigation wing clearly says that you conduct further verification and examination. Now, in this case, my lord, as I had mentioned earlier, and all the data spoke about Reliance General Insurance Company. My lord, the note or the reasons given, my lord, which is my lord at page 87, my lord, that mentions Reliance General Insurance Company, my lord. Yes. At page 87, that annexure of the reasons, that talks about transaction with Reliance General Insurance Company without mentioning that what is the transaction. My lord, after that, my lord, whatever information was given to me, the case-related information detail, my lord, that spoke about Reliance General Insurance Company and said no specific data or no specific document available against me. The department has given me dissemination report, which was issued by the investigation wing, conducted in the assessment of search of some other person. My lord, that does not mention my name. The statements don't mention my name. The chapter on Reliance General Insurance doesn't mention my name. Only one ledger or one detail, one table of, my lord, large vendors of Reliance. My lord, in that table, my name is mentioned and some intermediary appointed by Reliance, which is prudent, his name is mentioned. Just because of the fact that in some ledger of large vendors, my name is mentioned, that does not mean that there is information. It is a vague and distant information, my lord. But I place the decisions of the Honorable Supreme Court, including one, my lord, in Lakmani Mewal Das, my lord, which was, my lord, a case which was arising from a writ that was filed before this Honorable High Court, which travelled before the division bench, full bench, and then before the Honorable Supreme Court, wherein, my lord, it has been said that although the reasons can't be examined, the material, my lord, the sufficiency of the material can't be examined. However, it is necessary for the department and even the court to examine whether the necessary nexus or live link has been established between the information in the possession of the department and escapement of income chargeable to tax. That, my lord, in my humble submission, has not been done. And I've also placed on record, my lord, certain decisions of this Honorable Court in division bench, wherein, my lord, in the name of the assessee is there in the report. The assessee has entered into transactions with the alleged entry operators. But even that was not regarded by the Honorable Supreme Court in case of Lakmani Mewal Das, and even by this Honorable the division bench of this Honorable Court in Prashant Desai, to hold that would be sufficient nexus or live link for assumption of jurisdiction. And my lord, my learned friend raised the point that this is only a notice. I shall have the opportunity of addressing all points, including the point of jurisdiction subsequently. My lord, to this, my lord, I have already, my lord, placed before my lord the decision of Jeans Knit. And my lord, even the decision of GK and Driveshaft was laid down for the principle of giving the assessees opportunity to come before this Honorable Court after some order is passed, wherein, my lord, the assumption of jurisdiction is crystallized. And my lord, the order passed under section 148A3, that is not an appealable order. But my lord, that crystallizes the right, or that crystallizes the issue of jurisdiction. And my lord, I am before my lords not on the point of any facts or on merits, but I am before my lords on the point of jurisdiction. And my lord, in the case of section 147 proceedings, or 148 proceedings, my lord, the initial onus, my lord, is on the department.
Yes.
And the initial onus is on the department to show that there is income chargeable to tax which is escaped assessment by drawing that live link on excess. It is only after they discharge their own initial onus that, my lord, the onus will come upon me. In this case, my lord, the department in the order is mentioning prudence, but my lord, there is no data material with respect to prudence. And my lord, I cannot be asked to prove the negative because I don't have any transactions with prudence. I mentioned this in the writ petition. But to ask today or to tell me that where is your data with respect to prudence, my lord, I can't prove the negative. I don't have a transaction with him. So my lord, this is, my lord, my respectful submission before this honorable court. And my lord, lastly, my lord, the petitioner, my lord, is
the reflection of your name along with student in the sheet that has been annexed.
At page 158, your lordship.
Yes, page 158.
My lord.
What is the purpose of this? How is this correlated then?
My lord, if my lord may kindly take the page at 150, the document page 158. My lord, that is a part of the investigation wing's report. My lord, it is issued in the name of Reliance General Insurance Company Limited. It mentions, my lord, below that details of large marketing vendors during financial year 1890. And then it says marketing vendor, the name of marketing vendors wherein the name of the petitioner is mentioned. And my lord, name of insurance intermediary. My lord, this is a transaction. My lord, how does this show that there is income chargeable to tax which is escaped assessment? And my lord, this is only, I am one of the vendors, yes. Just because I've done a transaction with Reliance, it does not mean that my income chargeable to tax is escaped assessment, or it doesn't mean, and in fact, my lord, that is not even their allegation. They are relying on a document, my lord, which talks about large marketing vendors of Reliance General Insurance. That was the case made out to me. Now today they are saying, no, I want to talk about prudent insurance. And where is prudent mentioned? It is an insurance intermediary of Reliance. And where is my transaction with prudent?
Yes.
Well, these are my respectful submissions before my lords.
I'm concluding hearing.
My lord, only one thing is, if I'm permitted, my lord, the law has changed from the time the judgment cited by learned friend. Earlier, it was only that notice will be issued under section 147, small a. There, at that time, that point of time, it was not these rules were not framed. These procedures were not framed. Now it is after the judgment of GPM Drive Staff, the mandates of the Honorable Supreme Court has been incorporated in the statute itself. In fact, my lord, if my lord goes to the section 147, it says that during the reopening proceedings, if the assessing officer comes to any new facts, he can make addition on that. Though the rigors of 148A has not been followed.
If I can just say one line, I've already submitted nothing.
No,
I don't only, I've only filed before my lord, the decision of Karan Maheshwari. My lord, that is the decision of the Honorable Bombay High Court. My lord, that deals with the nexus theory.
You have cited Excel commodity,
my lord,
Greennet, then Kelvinator, then Lakshmani Mevaldas, Signature Hotel, and this Prasant Desai.
Karan Maheshwari,
Karan Maheshwari is not there.
Then that might, it's on the same principle. I'll not take too much of my lord's time. But the signature hotel is a decision wherein that nexus theory has been relied on of Lakmani Mevaldas in post GK and drive shaft decision. Same thing with Karan Maheshwari.
Karan Maheshwari is there.
Yes, sir.
Bombay High Court. Yes.
But Karan
Para
Maheshwari,
18.
yes, sir. It applies the same principle in 148A regime.
And Mr. Sharma has relied on
Renu
this
Singh?
Jharkhand decision, Gujarat High Court.
Yes.
Akshat. Pramod Kumar Chaudhary, Renu Singh, and that's all.
In this the principle of Renu Singh, my lord, it has been followed in earlier judgment, Anpul Jain also.
And the judgments and the order by which SLP against Renu Singh's order was dismissed. Three things.
But it is that matter that the principles have been followed in even various regimes. This principle holds good even till date.
Very well.
I'm grateful.
I'm grateful.
Third, Mr.
For the petitioner, Your Lordship, in this matter, the petitioner had challenged the order impugned on 3 counts, Your Lordship. The first was that the judgment cited by the petitioner was not considered. Second was that the petitioner had verified the Your Lordship had Your Lordship had asked me on the last occasion that since one Hariom Mishra on behalf of the exporter was giving me documents, who had actually issued the authorization. So, Your Lordship, I have written, it's there in my written notes, but the document, Your Lordship, may I hand over? It is not a part of the.
No, but if it is not a part of the petition,
It
I
is
cannot
mentioned,
take it like that.
Your Lordship, as Your Lordship would, just to show that it has fallen from Your Lordship that who had issued the authorization.
Yes.
Was it the exporter? Then
But that document must be,
Yes.
they should be confronted with the document first, because I will not be
Your
able to scrutinize.
Just
and-
to answer, Your Lordship, it was issued by the exporter. Now, Your Lordship, if required, I will. And the third point was, Your Lordship, that the order is on the basis of surmises and conjectures. There is no positive evidence against.
Want to bring it on record by way of supplementary?
Your Lordship, if at a subsequent stage, if Your Lordship thinks it is necessary, then I may otherwise. Because Your Lordship, there is, Your Lordship, I had said that it is my obligation to verify the documents. And I had the authorization from the exporter.
Is it apparent from the records anywhere that?
Yes, Your Lordship, page 170, Your Lordship.
Yes.
It is a part of my written note.
Page
But my written, my petition, Your Lordship, page 170.
Page 170.
Your Lordship, in reply to the show cause notice, I had said, Your Lordship, that the petition, Your Lordship, it starts at page 169.
Yes.
As the custom broker in the routine course of our business, we obtained, paragraph 4, the export processing job against 5 shipping bill of KSH International through intermediary Shri Hariom Mishra on receipt of all requisite KYC documents such as authorization letter, customer information sheet, cancelled check in the name of KSH, PAN card of the proprietor.
And how has this been dealt with by the officer?
Not dealt with, Your Lordship. Page 207, 208, Your Lordship, is the finding. He is not dealt with. He said that I should have verified physically and I should not have accepted the work from Hariom Mishra. I said that I had authorization from the
About the authorization, there is nothing spelled out in the
Nothing,
order.
Your Lordship. Page 207, 208, Your Lordship. Your Lordship, till 208, till the middle of the paragraph is my statement. Then he says, therefore it is evident. At page 208, Your Lordship, from the 8th line in the middle is the finding.
But what is your answer to page 209?
Your Lordship,
Just after one line, the beginning line at page 209,
Your Lordship,
in spite of not being an authorized license holder.
under the Your Lordship, I am the license holder, authorized license holder.
No, Hariom Mishra was not.
Your Lordship,
And
that
you have received everything from Hariom Mishra, who is not supposed to.
Your Lordship, this is a Ludhiana-based exporter. Your Lordship, he has authorized Hariom Mishra, Your Lordship, and he has handed me all documents on behalf of the exporter. And Your Lordship, one more thing, Your Lordship, all the parties, on the last occasion, I had shown that my statement, he was confronted with my statement. And because, Your Lordship, all the other persons, the warehouse holder, the transporter, and I was acting on his instruction because he was representing the exporter in Kolkata, Your Lordship. And Your Lordship, that's why this document is also relevant. Your Lordship, he has been described as the export executive of the exporter. And Your Lordship, this is the, that's why Your Lordship, if Your Lordship,
You can bring it on record, but then.
Your Lordship, I can find it by supplementary because I have stated these documents in.
And,
and Your Lordship, these documents are referred to in paragraph, Your Lordship, 35.
I am granting you leave, you bring it on record, you will have opportunity to traverse it.
Your Lordship.
Ms. Chaudhary, learned advocate appearing for the petition. Learned advocate appearing for the petitioner.
If it is not possible, let it remain in the list, my lord. Let Mr. Pardeep. I, my lord, I agree, my lord. No, tomorrow is not available. I have submitted before, my lord. It's not available today. Tomorrow he will be online.
Very well, Mr. Bhattacharya will be here tomorrow. You pray
Yes.
for time and
Deep love.
not to take. This was briefly taken up again today also. Yes, it's going to be for 15 minutes only. 13th November, and now a month has, more than a month has passed after that.
Lordship, after, because I have to also give reply. Subject to your Lordship.
No, this is a case of the straightaway notice under section 148 has been issued, because section 148A subsection 4 provides for an exception that where it is pursuant to information received under a scheme issued made under section 135A, then in those cases they don't have to follow 148A procedure. So there is a challenge therefore to that provision itself and to the annual section 148(3) clause 4, by which that whatever is conveyed is treated as information for the purpose of reopening. The satisfaction which has been disclosed with the notice note, that tells us how they are proceeding. So one of the aspects, these are all of course for the final hearing, but as far as the prima facie case is concerned, the basic the satisfaction proceeds on the basis that 264 crores of income has not been accounted for in the books of account, and 44 lakhs interest received from the income tax department has not been accounted for in the books of account. That is the satisfaction recorded. Now there was no proceeding in which the books were examined so that any such conclusion could be arrived at, or even because if the starting point of this was not the Form 26A. The Form 26A discloses who all have deducted income tax source from the income paid to me. So it discloses the amount of income, it discloses tax deducted at source. And the law is that if I claim credit for the tax deducted at source, that income must be offered to tax in the return. Otherwise, I cannot claim credit for the tax deducted source. So in this case, if they had even cared to look at the return, they would have seen that this entire amount has been claimed as credit. The tax deducted at source has been claimed as credit. And even before issuing this 148 notice, there was a query to me under section 133(6), asking me, referring to the tax deduction details, that this is the amount from which the 264 crores from which so much of tax was deducted, so much was the interest you received from the income tax department. So how have you shown it in the return? So the answer given was that this amount has been offered to tax under the head business, and therefore it is not, because it is the query procedure on the basis that is house property income and should have been offered under the head house property. So the query was whether it has been shown under the head house property. The answer was that no, it has been shown under the head business, and that is how I've all along been assessed. So it is there, and it is not something which is, because there are prior assessments in my own case under section 143(3) where it has been assessed under the head business with the deduction which is available to me under section 80 IAB, because I am developing infrastructure for information technology and information technology enabled services, and there are special economic zones which are providing this. I am a developer under that scheme, and I get the deductions. So this I've been allowed the deductions. Scrutiny assessments have been made. So this query, when it was raised, I gave the answer, but they seem to think that I've kept it out of the books. That there's no discussion about the query and answer, or that they have looked at my income tax return for this year. Because in the return, Mr. Ketan, if in a case where 148A 123 procedure is not required to be resorted to,
Lordship.
and a notice under section 148 is issued,
Lordship.
would the assessee not be entitled to ask for the reasons as it would have asked
Lord-
in the earlier regime?
Lord, I'm grateful. Lord, that is why the GK and drive shaft.
Yes.
Lord, that was the principle which was invoked. Because Lord,
So
where,
here in this case, you asked for the reasons.
Lord, the reasons, letters, not the reasons to ask. Just check. Lord, I'll tell my Lord, Lord, after the
I
notice.
just wanted to see what was the reason
Lord,
then
Yes, Lord. Objection was filed. In fact, objection was filed, Lord, which is.
to the reopening.
Yes, Lord, page 521. With the principle that could be relied upon, Lord, and is
Yes,
can drive.
because then that will apply.
Yes.
If 148A procedure is not applying,
Lordship.
then GK and drive shaft principle will apply there because it's the same thing again.
Yes, Lord, because it's a jurisdictional notice, Lord.
Yes,
That's what-
yes.
Because when the reasons were not apparent from the, kindly Lord, have a look at that satisfaction note. Lord, it's in volume 4, Lord.
Volume 4, yes,
Yes, Lord, page 489.
489.
Forty 489 is the notice under section 148. And paragraph 3 says this notice is being issued after obtaining the prior approval of the specified authority accorded on terms of that is at page 490.
Yes.
490 Lord, is the pro forma for approval, and Lord, the 492 Lord, paragraph 3. Information has been received from the CBDT in the case of the incident assessee through departmental insight portal under the category of high risk e-verification scheme, wherein it was reported that the incident assessee had failed to disclose an amount of rupees 264.56 crores towards interest from income tax refund and rent received. Not interest from income tax refund is some 44 lakhs, and the rest is what they want to call rent received during the financial year 2021 in its books of account, and hence evaded taxes accordingly. So this is the foundation. This is the foundational fact Lord, being assumed without even looking at the books of accounts.
And to this objection was raised.
Yes, Lord, the objection Lord is at page 521.
That has been dealt with, no?
No, Lord. They are not dealing with this because they seem to think that there is no statutory procedure anymore. 148A is dispensed with, so Lord, they think that it is not.
Yes, Mr. Dhuria, this seems to be a jurisdictional error because GK and drive shafts will get attracted.
These were section 135A.
135.
135A.
Yes.
And I will also not ground wise, not I'll controvert this. 135 capital A.
135 capital A. Yes.
The government may make the scheme of notification on basis or for the purpose of political information on collecting correct information or collecting information by the state income tax or to the power of the company under 134 or the extent of power to execute as to require the gathering of by deliberating the interface between the income tax authority and the or other person to the extent of technological feasibility, the optimizing the utilization of the resources to economic scale and functional specialization, introducing a zone-based exercise power, distribution power to collect and collect or process or utilize information with a dynamic jurisdiction. The central government made for the purpose of giving effect to one by notification the official gazetted direct that provision to the act or apply and shall apply to apply with the extensions, modifications and adaptations that may be specified in that notification provided that is clear that no direction shall be issued on the after.
I've read it.
Yes, Your Lordship, so my lord, this my lord, section 135 of the Act my lord provides a scheme for the purpose of collecting information. So 135A also provides the central government may, for the purpose of giving effect to the scheme, direct that any provisions of the Act shall not
Will not
apply.
apply.
Yes, yes. Accordingly, my lord, accordingly, e-verification was notified. From the e-verification I'll show it to Your Lordship. My lord. There was a scheme, e-verification scheme of 2021 was notified. On 13/11/2025, the scheme provides among other things the modalities for electronic collection and verification of information, the mechanism for collection of information into low risk and high risk. Certain the scheme also mandates the high risk information should be utilized for further necessary actions in accordance with the provisions of the Act. The provisions of the Act about the information obtained under e-verification scheme is provided. The information under such an e-verification scheme, it is stated that notice under section 148 cannot be issued without prior approval of specific authority. The second is not before the issuance of notice under section 148, the AO did not follow the procedure mentioned in section 148 capital N in so far as the information received under section 135 capital N. That is there in the scheme, that I will place. Based on this legal proposition, the e-verification depending based on this legal provision, the information remaining after the closure of a low risk cases for e-verification was passed on to the specific authority or judicial authority for necessary action. Under the Act, that means the e-verification instruction number 1, dated 11/3/2023, and associated provision of the SSC. The contentions are Lordship will kindly see the e-verification. I'll place for Your Lordship the e-verification scheme by virtue of which says that no procedures is required to be made.
Page 504.
Page 504. Yeah.
No, question is, even if it is not there, it was not there in the statute when this 148A was not inserted also.
Yes, yes.
Then also the Honorable Supreme Court had held.
Yes.
So this does away with the statutory applications.
Yes.
But what about the requirements by, because of the
I understand
principles of
the
natural justice? These
DKB and
requirements are already, they are inbuilt.
Yes, yes. That is inbuilt.
It was not there even then.
Yes.
It is not there today.
Yes.
The provisions which you read will make certain provisions not applicable in a given set of facts.
Right.
But in a situation where the Honorable Supreme Court has already held something to be applicable, whether that will also not apply.
That is the that will apply. But what I'm humbly submitting, this issue, is regarding the issue is that certain
things, proceedings are going to be time barred in
March.
So I'll keep it as a continuing matter immediately after the reopening, and I'll finish it then, because it appears to be short and interesting point.
Yes.
So that it comes up.
Yes.
It's a continuing matter.
Fifth or sixth, any day, subject to that.
Yes. Fifth, we can have it.
Yes.
Third, Mr. Khetan.
Item 58 and 59 was
Tomorrow the other bench will be available.
The other side is also there, players are very innocent. The difficulty is, we wouldn't have troubled your lordship. The authorities are waiting there, to undertake, the demolition.
Pending, writ petition is pending. They won't do it. They won't do that.
They are not listening. Today also, there was a huge harassment today.
Tomorrow the bench is available. Tomorrow.
What we want is,
right of hearing, I understand the state will not also stand in the way. The proceeding which is to reach the logical end pursuant
And
to.
who is appearing for the state after 4:30?
Only 1958. Yes,
So
58.
it's already 4:30, not
But
not
any
proper,
one-
because tomorrow the bench is available. Look at the situation. It won't order well tomorrow. Tomorrow it will appear before
Bench
Satrapati
appear at the
bench.
top, my lord.
Tomorrow I will not be having determination. That is the problem. That is why I'm unwilling now. It won't look nice. Tomorrow it will be there in the list. You are going on a holiday tomorrow.
Oh, my lord, I am told, my lord, code 19 is the bench for having the determination.
Then also you get it assigned before the other one. That won't be a ground for me to entertain. Thank you.